of the Board of Ethical Conduct. I'm Chair Young, and I am calling the meeting to order. And if we could have a calling of the roll by the clerk, Mr. Kyle.
Chair Young.
Here.
Ms. Diani.
Here.
Mr. King.
Here.
Mr. Savis.
Here.
Mr. Wicker.
Here.
Mr. Wilson is not present. Councilmember Porterfield.
Present.
Yeah, 6 members in attendance.
Thank you, Mr. Kyle. So we have a quorum to proceed, and I'm told that there's no one signed up for the public comment period, so we can move to the third item on the agenda, which is approval of the minutes from our last meeting on May 18th. I trust that the board members have had a chance to review the minutes, so I will entertain a motion to approve. Second.
Second.
Is there any discussion or corrections to the minutes? Any objections to approving the minutes? So the minutes are approved. And Mr. Kyle, can you read our notice of appeal rights?
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. So the fifth item on our agenda is the hearing of the complaint by Melanie Cochran and Elizabeth Sullivan versus Councilmember Courtney Johnston. It looks like all the parties are present. Is that right for complainants and respondent? Okay. So we'll proceed with the hearing. I trust that the complainants and respondent have seen a copy of the hearing procedures that are made available, so I won't go through those items. So I'll just ask, are there any preliminary matters or motions that we need to discuss before we start the hearing?
I would just like to point out, my name is Brian Pieper, and as of this weekend, Ms. Sullivan has asked me if I would represent her in this matter. I'm an attorney.
Thank you. Mr. Pieper?
Pieper, yes.
Okay, thank you. Anything else we need to hear? Okay. And Ms. Johnston, you're represented by counsel?
Yes.
Okay, so we'll start with opening statements. Well, first, can I get an estimate of how much time you think you'll need for your presentation today?
In total?
I'm going to say 30 to 35 minutes
Okay.
to go through our documents.
Okay. And respondent, do you have a sense of how long you'll take?
10, 15 minutes.
Okay, perfect. So we don't need to establish any kind of lunch break or anything like that. But if anybody needs a break while we're going, please speak up.
I do have a question, just logistically, where to set up. We've got quite a few documents to go through. Where will the witness sit? I intend to get them in through Ms. Sullivan.
Okay.
Where would you like me to be? Where would you like her to be? Since we don't really have a counsel table as we might in a courtroom.
You are correct. So this is the seat for the witness here in the middle. I don't know where it makes sense for counsel to present.
There could be another seat where counsel and the
Could
witness
be
sit.
at the same table.
Yeah, when each side comes up.
Does that work for you, Mr. Pieper?
They're suggesting that we sit side by side right here.
Well, on this edge, so it's kind of like at an angle to each
Okay.
other.
That's
You
fine.
or you can maybe scoot that chair towards that end and have a little bit more separation.
Is it okay with you all if I move it back just a smidge?
That's fine with me.
Okay, and I have one question. That echo, can we shut the door?
We can.
Okay.
And
Thank
I
you.
agree. It is
Thank you.
Distracting.
Thank you very
Thank you,
much.
Mr. Wicker. Okay. Oh,
I'm
yes.
sorry, I do have one question. It may have been in an email, but I didn't see the hearing procedures that you referenced. So are you going to do openings? If you could just read through those real
Okay,
quick.
sure.
And I'm sorry, one more thing. Where's the camera?
The camera is in that corner.
Okay. Thank you.
All right. Okay, so with this hearing, the parties are allowed but are not required to submit material to the board. We did receive both sets of materials that you submitted a week in advance, so thank you for that. If there's anything that you are citing or trying to rely on that wasn't submitted, we won't allow that because out of fairness to both sides, we'd like for you to have those materials in advance. This is a full and fair opportunity to hear the matters, but it's not a courtroom, so we will follow these procedures, but they're not the same that you would necessarily see in a court. Each party has the right to assistance of legal counsel, and you both are represented. Each party shall be allotted a reasonable amount of time to make its presentation to the board. There aren't strict time limits, but we will, adhere to a reasonable standard. All parties may call witnesses to give testimony at the hearing, which testimony shall be given under oath, and Mr. Cowell will administer that oath to the witnesses. All witnesses will be subject to cross-examination. Each party must file with the clerk a list of the witnesses that the party intends to call at the hearing and provide a copy of the same to the other parties at least 7 calendar days prior to the hearing. At the hearing, no party shall be permitted to call upon any person to give testimony if that person's name was not included on such list. However, the board may permit such an unnamed witness to be called by a party if, in the board's judgment, there was good cause for not timely naming the witness and the other parties would not be unduly prejudiced. Board members may ask questions of any party, counsel, or witness at any time during the hearing. The board may, in the exercise of its discretion, permit interested persons present at the hearing to offer testimony under oath, even if those persons were not called as witnesses by any party. The board may continue a hearing to a later date. The director of law or metropolitan attorney shall be present during the hearing to advise the board.
Okay, yeah, so there are hearing procedures reflected in the rules of the Board of Ethical Conduct. So I can bring those to you that outline the order of proceedings.
Okay. Do I not have a copy of that?
It's on the back side.
It's...
On the back side of the one you just read.
Oh, okay. Okay, yes, I have it.
Oh, okay. Okay.
So to continue, hearings shall be conducted in a professional manner. The order of proceedings are set forth as follows. Both parties have the right to testify, produce and examine witnesses, cross-examine adverse witnesses, and introduce such other evidence that is relevant and material to the issues determined by the board. The order of proceedings shall be as follows. The hearing is called to order. Any preliminary motions, stipulations, or agreed orders are entertained. We have opening statements. Both parties may but are not required to present opening statements to the board. If the party so elect, the complainant shall present his or her opening statement followed by the respondent. Presentation of evidence. So you have the complainant's case in chief. So the complainant shall present evidence supporting his or her case against the respondent. For each witness called, the complainant questions, the respondent cross-examines, the complainant redirects, and the respondent recrosses. Respondent's case in chief, the respondent may present evidence supporting his or her case. For each witness called, the respondent questions, complainant cross-examines, respondent redirects, and complainant recrosses. Rebuttal. After the respondent rests, the complainant may present rebuttal evidence in the mode set forth in section 4A, which was the complainant's case in chief section that I read. And then we have closing arguments. After the close of evidence, the parties may present closing arguments. If the parties so elect, the complainant shall present his or her closing argument followed by the respondent, followed by a rebuttal by the complainant. The burden of proof rests with the complainant, and the standard is preponderance of the evidence. The board has discretion to limit the number of witnesses and time permitted for each party to present evidence and argument. Regarding legal counsel, the board may call on its legal counsel for input at any stage of the proceedings. The board may enter into executive session to hear and consider advice from the board's attorney. And I think that's it. There's a section concerning action of the board, and that comes after we've decided if there's a violation.
Okay, thank you.
Any other questions before we proceed? Okay. Mr. Pieper? Would you like to start with the opening statement?
I would. Where would you like me to stand?
Wherever you like.
Okay. The complainants in this complaint against Councilmember Johnston have alleged several violations of Metro Code Chapter 2.222, Standards of Conduct, Disclosure of Interest, and Enforcement. Those are laid out in the statement that Ms. Sullivan, prior to my entry, already filed, the first of which is a no-brainer because they don't deny that there was a violation. The first one is that she had a position on a nonprofit board, and contrary to law, in her disclosure, where she was specifically asked, do you or your spouse have any such position, paid or unpaid? Her answer was no. Now, we've been talking in terms of failure to disclose. I think we should recouch that. This was actually a misrepresentation. This was a falsification of her disclosure. This was not simply an omission. So they don't even deny that that violation occurred. So without more, there has to be a finding that there was a violation. Now, with regard to that first one, though, really what they argue is it was an inadvertent oversight, and so they request that she get the lowest level of discipline, which is a written warning. We would contend that under the circumstances here, that is not sufficient, that there needs to, at the very least, be a censure. When we get into the broader circumstances, an argument could be made that removal from office might be warranted. But at the very least, a censure is appropriate. Now, we're not even going to ask for referral to the DA or legal action by Metro Legal to recoup monies, because we're not aware of anything criminal or anything like that. But censure is what we're asking for. Now, they go to great efforts to really downplay the violation that they admit by, and as Ms. Sullivan stated in her well-crafted for a non-lawyer statement that she submitted, when you look at what the Metro Code states as the reason for that disclosure requirement, it's important. It's not something that should be downplayed the way she wants it to be downplayed. In fact, and this is also found in the Metro Legal report after reviewing the complaint, Metro Code Section 2.222.030B1D states, the purpose of the disclosures is, quote, to alleviate reasonable concerns, justified or not, of the public concerning possible conflicts and influences on the Metro Council member. So that's important. The purpose of these required disclosures is that let's focus on the justified or not, even if it turns out that there wasn't stealing, there wasn't self-dealing, there wasn't something criminal, doesn't matter. The very fact that she misrepresented the facts on her disclosures is important, because that's the only way, that kind of transparency is the only way that citizens, residents of Nashville, can have confidence in their elected representatives. So this should not be downplayed the way they want. Now, in a moment, as part of my opening, I want to go through the false statements in her statement and allude to the documents that we are going to present that we actually obtained from her in an Open Records Act request that directly contradict those things. But with regard to this first point of her saying it's really not a big deal, one of the arguments is, well, and this comes from their statement, she really wasn't aware she had been voted onto the board because she'd only recently gotten on, and she had told them that at some point in the future she'd be willing to be on the board, but gosh darn it, she wasn't really sure when she even got on it. That will be directly refuted by documents that show that this false statement that she signed under oath, the disclosure, in December of 2025, comes 6 months after lots of activity where she's showing up at least one board meeting and numerous board emails. So that's going to be directly contradicted. They're going to say, oh, it was an easy mistake because the museum board wasn't meeting frequently and she simply forgot to list it on the disclosure. Again, the documents are going to show lots of communication about her involvement on the board. She was not under any illusion that she wasn't on this board. She was an active member of the board, not only meeting in the one board meeting that they had during that period of time, but meeting with big hitter members of the community. So that argument that this is just an innocent error doesn't fly. Now let's turn to the other violations, because you really can't read the falsified disclosures violation in a vacuum. You really do, as Ms. Sullivan states, need to read it in light of the other violations, that while not disclosing her involvement, in fact, while denying her involvement on this board, these other things occurred. And this is, what's important is to keep your eye on the actual legal standard of the provisions that we're pointing to. Because in the affidavits that they provide in support of Ms. Johnston's argument, several of the things they say are just flat contradicted by the documents that we got from Ms. Johnston. Other things that they say are irrelevant because they misstate what the requirements are for a violation. So let's talk briefly about what these violations actually require. And we're looking specifically at Metro Code section 2.222.020, subsection K, Q, and O. All that has to be shown is that did what Councilmember Johnston do create a reasonable basis for the impression that someone can improperly influence her, or that someone will unduly enjoy her favor in her council duties? The second violation is, did she act in a dual role, promoting the interest of this nonprofit board we're talking about, which, by the way, is the Music City Children's Museum, which is it's an entity that was created in 2014 but has never done anything. I mean, there's never been a museum, but the entity has existed since then. Did she act on behalf of that entity as well as on behalf of the investor group that was purchasing the land in East Bend and utilizing that, the potential of having that children's museum there as great PR to get sympathy for their zoning change? And there's nothing wrong with that. That's actually just smart strategic PR. But what is concerning, though, is when you get elected officials involved in that effort. Did her multiple relationships pertain to a matter that she was voting on before the Metro Council? Absolutely. That's Q. Did she, by virtue of her relationship with not only the Children's Museum, but also the investor group's lobbyist, and you're going to see a whole bunch of emails. You're going to see a lot of communication with Sam Reed, who represented the investor group and also sat on the board of the Children's Museum with her, very directly advancing the interests of both the Children's Museum and the investor group. Now, by doing so, did she, and here's the standard, engage in outside activities that might impair her independent judgment in the performance of her Metro Council duties? And that's an example. When you get to their affidavits, they say you can't prove that it did influence her independent judgment. That's not the standard. Did she engage in outside activities that reasonably could be perceived that they might interfere with her independent judgment? Because these standards are all about public confidence. This is not about finding an actual crime, actual theft, actual self-dealing. It's, were there relationships outside or activities outside of council that create these concerns with regard to her council duties? Now, when you layer that on top of the fact that she misrepresented whether she was on a board at all, these are serious violations. I want to quickly walk through a few of the things stated in Ms. Johnston's response. One of them is that this entire case is built on a single text message in which she stated to a resident that she was working with, that she, as a member of the board of this nonprofit, was working with the investor group who was wanting to redevelop the East Bend. No, the documents will show this is not based on that single text message. That single text message might have been what caused the citizens to start digging because what she said gave them grave concerns. But the documents will show that she very clearly was doing so. They offer an affidavit of Cindy Clinton, who is the chair of the Children's Museum. And she says, and this is where the wordsmithing in the affidavit is really great, she was never expressly asked to advocate on behalf of the museum. She was not asked to vote for the ordinance. She was not asked to be involved in any communications with the East Bend Development Group. Now, first of all, that last one is directly contradicted by the emails that we got from Courtney Johnston and the board minutes and numerous other documents. So it's just false. But even if these things were true, that's not the standard. The standard does not require that she be expressly retained to do so. What matters is that she did so. And the documents are going to make it very clear that she did so. They also offer an affidavit from David Byerly, he is the CEO of one of the entities that is part of the investor group behind this East Bend development project. And he says that he had one and only one conversation with Ms. Johnston in which he admits that she made the initial introduction of him to the chair of the board of the Children's Museum. But he says after that she had no involvement. In her statement, they repeatedly say that this is all based on one single act on her part, which was the introduction of David Byerly of the investment group to Ms. Clinton, Cindy Clinton, who is the chair of the nonprofit at issue. That is not true. There are numerous communications beyond that. When they say that she was not involved in the conversation with the investment group after that, that's flat out false. By the spring of 2026, we will show through the documents that we got from her, she was one of the two most active people driving the conversation with the investor group on behalf of the nonprofit while voting on a rezoning request. And I'm going to call it the rezoning request because that's what Ms. Sullivan called it throughout her documents. We're talking about ordinance number BL 2026-1273, which established certain land use and development standards for the East Bend subdistrict as part of the downtown code. In their documents, they refer to it as the DTC bill. We're talking about the same thing. I'm going to stick with rezoning because that's what's been written thus far. We're talking about the same thing. So she is simultaneously on the board of a nonprofit while voting on the board of a nonprofit while voting on a rezoning requested by a development group that is using that nonprofit as PR to say, if we get this zoning change, this children's museum will have a home here. And so she is absolutely benefiting the nonprofit. I mean, she's got this isn't a matter of no person can serve two masters. She's got three masters. She's number one, she's got her duty of loyalty as a council member to the people that elected her to Nashville government. Number two, she's got her duty of loyalty as a board member of the Children's Museum that will directly benefit if that rezoning happens. And number three, given the fact that Children's Hospital, the documents are going to make it pretty clear, the Children's Hospital's only in the conversation at all because it's a very convenient prop. It's a convenient prop for the developers to be able to get people to want them to get this rezoning. Because, if you oppose it, then you must hate children's, I think I said Children's Hospital a minute ago, children's museums. Why do you hate children's museums?
I don't mean to interrupt.
Yes.
What is the third half? You were
The
saying
third
there-
relationship?
Yeah.
Yeah, she has basically three interests that she's
Right,
serving
right, right. I got the
simultaneously.
first two.
The
What-
first,
got it.
yeah, Metro.
What was the third?
The third is the investor group, because given the fact that the only reason the nonprofit on whose board she sits is even in this conversation is because it is a convenient way to help the investor group get what they want in this zoning change. Let us get there with the documents. The documents are clear in their press releases, in Byerly's statements to the media, in Ms. Johnston's statements in emails to constituents. It's clear all over the place that really this inactive entity that nobody cared about 5 years ago suddenly is being touted as a reason why these investors should get the zoning change they want. So by advocating for the zoning change, she's also benefiting an organization on whose board she sits, which is only in the conversation in order to benefit the investor group. I mean, there are so many entangled duties of loyalty here. This should never happen. This is not a simple violation. This is serious, even without direct money in her pocket. And that's something else they do. They say things like she wasn't paid to represent the investor group or the nonprofit. She wasn't specifically retained to do so. None of those things are in the standard that she violated. None of them. They're irrelevant. They're moving the goalposts. I'm going to wrap up. Oh, and here's a good example of moving the goalposts. They argue that, she was never asked to vote for, she was never told that in exchange for her vote on the ordinance that this nonprofit on whose board she sat would get a home. There is no requirement of a quid pro quo in any of those standards that we read. Nothing requires that there be an explicit agreement that if you vote this way, we'll give this entity that you're on whose board you sit this benefit. That's not required. What is necessary is she was working for all three at the same time. They state very falsely, as the documents will show, that I'll just read from her statement. The attached affidavits show that Councilmember Johnston's involvement was limited to an initial introduction between the East Bend ownership group and the museum. False, blatantly false, and you'll see that. They do not show that she attempted to secure any benefit for the museum through the bill. Also false. The documents will show that false. Or that her vote was unduly affected by her museum affiliation. The standard isn't was. The standard is she engaged in things that could affect her neutrality. They further double down on this argument that the affidavits show she had no further discussions. That is so untrue. As I said earlier, by the spring of 2026, she was one of the two people primarily driving those discussions with the investor group. Finally, she says, Councilmember Johnston went so far as to seek counsel from a Metro attorney about whether or not she would need to abstain. And she was told that unless it benefited her personally, her personal interest, she did not. Now, I don't know what Metro legal attorneys she's talking about, but they certainly weren't reading the provisions that we've been reading. I don't find that plausible at all, that she got legal counsel. But if she did, I can almost guarantee you this, and if she testifies, we'll ask her. Did she share, in asking that question of counsel, getting advice of counsel is only valid if you fully disclose to counsel all the relevant circumstances. I can't tell them half the story and then rely on their advice. So did she share with them all the emails and all the documents that we're going to share with you today that show these twisted and intertwined relationships between her, the investor group's lobbyist, Sam Reed, and the nonprofit? I doubt it. In fact, I can almost guarantee she did not. So we live, perhaps in the last 30 years, more than any other time in our life, we seem to be living in a time when certain people, elected people, wealthy people, just think the rules don't apply to them on every level. We see it federal, state, local. This board can't do anything about that on a state level or on a federal level, but you absolutely do have the power to do something about that, to stop that in the Metro Council. In fact, you have the responsibility to stop that in the Metro Council, and that is simply what we're asking that you do. Thank you.
Thank you, Mr. Pieper. Would you like to make a comment?
John Cooper with law firm Holland and Knight, representing Councilmember Johnston. I'm going to use this as an opening statement. You've heard lots of words here a few minutes ago, a lot of twisted, convoluted relationships and how there's just all kinds of really bad stuff going on. Frankly, this is going to be shown to be much ado about nothing. And first of all, the non-disclosure. We stipulate that Councilmember Johnson failed to disclose her membership on the board. That is absolutely true. But there's a big difference between non-disclosure and misrepresentation. And in my presentation, I will show that she could not have misrepresented because she was telling all of these constituents in the emails that Ms. Sullivan provided to you that this development's going to be fine. They're actually working to see about having a children's museum there. So she wasn't disclosing that her involvement. She wasn't misrepresenting her involvement. So I think that's a very key point. I would also note that the council legislation in question, the vote was 37-0, and Councilmember Johnston did not speak on the council floor. This was a well-supported development that went through lots of public discussion. And so Councilmember Johnston's involvement with the museum had no impact on anything regarding the legislation, which is what we're here about, is this piece of zoning legislation. So we submit that she acted as a council member. She voted as a council member. She did consult legal counsel about whether she needed to abstain and was told no.
Can I interrupt you? Who did she consult? It says a Metro Council attorney. Do you know who that was?
Brian Wilson. You've also heard things about Sam Reed and his involvement. Sam Reed is a lobbyist. He lobbied on behalf of the development team. He's also a board member of the museum. But her involvement has to be separated from Sam Reed and his interactions. The fact that Councilmember Johnston communicates with the lobbyist regularly, if you submit a public records request for all council members, you're going to see lots of communications with lobbyists. That's the way the system works. So I will leave it there. We'll let them get into their case in chief, and then I'll respond accordingly. Thank you.
Thank you, Mr. Cooper. Mr. Cooper, would you like to call a witness?
I would. I'm going to call Ms. Sullivan, Elizabeth M.K. Sullivan, the complainant. And give me just a moment to get set up.
While you're doing that, we'll swear the witness in. Mr. Kyle, please.
Would you slide around a little so that I have a little more room?
Mm-hmm. Sure.
Do I stay here for that?
Yes. Okay.
Ms. Sullivan,
Yes.
do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
I do.
Prior to my involvement in the case, Ms. Sullivan, as you know, submitted quite a few PDF documents, and so therefore, which you all have and which opposing counsel have. Going through them in the last few days, we are only going to discuss a smaller subset of everything that she submitted. But what I will try to do With regard to the documents that I do have her describe and discuss, when handing them to her and asking her about them, I will tell you the name of the PDF that they come from. That way, if it doesn't look like anyone is live time wanting to, look the documents up while we discuss them, but at least you'll know which PDFs they come from in case you want to look at it later.
Does everybody here have all of the documents I submitted, like, on paper? Okay, just checking, thank you.
And this is unusual for me as a litigator, but given our setup, I'd like to sit, so if you don't mind.
That's fine, please.
And I apologize, Mr. Wicker, that I'm blocking your view. The overwhelming majority of the documents that we're going to discuss were obtained by virtue of an Open Records Act request that Ms. Sullivan submitted. And so they ultimately would have come from Metro and from Ms. Johnston herself. There are a couple of documents that she obtained on her own that she'll testify about, such as a text exchange between her and Ms. Johnston. I'm going to walk her through them and have her, I'll just walk her through them. So the first thing I'm going to hand Ms. Sullivan comes from the PDF named Email Set 1, and then a few of the pages come from Emails Set 3. Ms. Sullivan, would you please tell us what these documents are?
Sure. So, does everyone have the document in hand that we're discussing? The date is Wednesday, July 30th, and it says Music City Children's Museum in the center. It comes from Email Set 1.
Okay, so we don't have the email sets, we don't have the PDFs, the titles.
Oh, you don't have the
We
PDF?
printed,
Okay.
no, we have
Oh,
the
you printed
documents.
them out.
We printed them out.
Okay.
Now, there's numbers on, at least the version I have, that could be helpful.
Some of them.
The numbers.
One second. So there were 9 documents with specific titles presented, but it sounds like it's all in one space for you all. Is that correct?
Yeah.
Okay. Well, given the circumstances, what would you like to do?
Why don't we just identify it more specific? It might take a little longer, but let's just identify it more specifically by date and by title of what it is.
Yeah.
Well, this is the packet that the board members have, if you want to reference that.
Can I see that when you're done?
This is the
please?
full packet of all the documents?
Yes.
Oh, it's double-sided. Okay.
I mean, that's fine.
That still doesn't seem.
May I
like
see
nearly
it?
all of it. I mean, if we're going to go through and, I'm sorry, I assumed you would have them in their PDF forms and you'd be able to go electronically to the PDFs when I named them. But if you printed them out,
Let me just look and see what they have.
okay.
Is this your copy, sir?
No,
Mr. Kyle? Okay, whose copy is this?
it's an extra copy.
Okay, so we can reference this copy. That's what we'll do.
I guess if we're gonna, all
Well,
right.
that's
well,
what we have to do. I
There
know
it is,
these
there it is.
documents very well.
Are these numbered? So can you tell them at page number? No, they're not. Okay.
Well, 15 pages in.
Okay, thank you. Yeah, so I'd go about after the text message piece, after the documents showing emails. Yeah, so there's one that's red with the number 7 at the top, and it's right after that.
Got it.
Okay. We're in no hurry, so please take your time.
Well, maybe. That's up to them, whether we're in a hurry.
When-
Also, for your reference, it has the heading Music City Children's Museum Board Meeting Minutes.
Yeah, in this,
first
kind of
page
in the
does.
center.
Ms. Deani?
Keep
It's right after the 30th. That's it.
Okay. Are we ready?
Yes.
Okay. So the question is sort of what do we have here?
What is this document?
So the first document is from July 30th, 2025, so almost a year ago. And these are board meeting minutes from the Music City Children's Museum, in which numerous people attended, including Councilmember Johnston.
Does the content of these minutes reflect that she was, besides showing up to the meeting and appearing as a board member, does it show any activity on her part?
Yes, if you'll turn the page, at the top, you'll see 2 red lines. And what this indicates is that Colin Reed, lobbyist Sam Reed, and Courtney Johnston met to discuss something regarding the zoo that's unrelated to this matter.
And some others, would you?
Yeah, and there's some others here, Butch Spearden, Jimmy Granberry, Rich Schwartz. These are obviously high-level members of the Nashville business community. After that, as you flip through the following pages, you can see there are numerous board member emails regarding the museum from Ms. Clinton to the board members by email, including the council member and lobbyist Sam Reed. And you can just see that there's quite a few emails. These are all throughout 2025. And that goes on about 10 pages. Did you want me to say anything more about this document?
No, I would like you to then discuss what the next several pages in that packet that I handed you are, and I am trying to find where that is in the collection that the board has.
Oh, because, yeah, some of these are in email set 3. Is that what you're getting at?
Yeah, some of them are in email.
But
set
look, these
3.
are just general emails. Some of them are in set 3. There's nothing complicated about it. It just shows that the council member was receiving emails from the board chair, Cindy Clinton, for months, all throughout 2025, before the disclosure was required. And then, can I move on to this?
Some of these, and the problem is what I've handed you is not a straight set in this document that they've got.
I understand.
If I could just interrupt a second. So the respondent has stipulated that Councilmember Johnston was a member of the Children's Museum. Is this line of questioning intended to show something beyond that?
Yes. What is still to be determined is what is the appropriate remedy. And what we're going to show is this argument that, oops, I forgot because it wasn't very active, when in fact there were numerous board emails going around. She was very aware of her involvement. And as that document just showed, she was not just attending the meeting, she was out in the community meeting with the heavy hitters on behalf of the Children's Museum. This wasn't something that she can just say, oh, it was an easy thing to have overlooked.
Okay, can I talk about this?
Oh, yeah, what is the final
So, and
page?
then the last piece I'd like to show regarding the council members' activities in 2025 is that her name is listed on the museum website, along with Sam Reed and some other powerful people in town. So, next.
Just really quickly,
Let me talk about this.
just tell us what that is.
Very quickly, in November of 2025, this page, this is an email from lobbyist Sam Reed for the investor group, also on the museum board, inviting the full council to a reception on behalf of David Byerly with the investor group. And this is November 2025. And then the rezone bill was introduced to the council in January. So this is right prior to a rezone conversation.
And I'm looking for it in your packet.
We've seen it, but what is
Okay.
the relevant?
Okay, yeah, the relevance of this.
It'll come later.
Well, but let me address it.
Okay.
The relevance of this, because it is absolutely true that lobbyists are going to communicate with elected officials. That's what they do. They're lobbyists. And so it's not merely the fact that there were communications. In fact, we've got reams of communications that are just run-of-the-mill. Sam Reed, who represents the investor group, also represents a number of other of other clients saying, Councilmember Johnston, I'd really like it if you voted this way on this bill. That's normal. I mean, I understand that. Now, the volume of it does indicate quite an ongoing relationship, but even that's not an ethical violation.
Let me just say my
But what
question.
is,
My question is about the specific
Right.
document, about the invitation to all council.
This is not by itself problematic.
We
but
just highlighted,
the-
I was just wondering
right.
what the relevance of that particular
In
document
the
is. since it was
timeline,
to all
this is,
council.
sorry, I didn't.
It was to all council. It was an invitation to an event
Yes.
for
It
all
comes
council.
up in David Byerly's affidavit.
This is the meeting in which David Byerly claims that Courtney Johnston introduced him to the chair of the nonprofit. And this is really more for setting a timeline than anything else. This is not a smoking gun in any way. I mean, this is normal communication. But that's where it fits in the picture. I really was hoping to just burn through that one quickly. It is normal communication, but it kind of sets the stage for the timeline
It
of what's
addresses,
happening.
I think, Mr. Byerly's affidavit,
Yes.
which will come in a little bit.
I'm going to hand you another document and ask you if you could tell us what that is.
Okay, so we are now looking at the packet that says text messages.
And ethics is, but
And
they don't,
ethics
they don't have it
disclosure.
that way. They have it in this packet.
Looks like this. There was a typo on the page. I'm just mentioning it because it helps us visually find it.
To help you save time, it's her December 2025 disclosures. So
Yeah.
six months after she's become active on the board, at least 6 months after. We only have documents going back to June.
Mm-hmm.
But at least that long, she's been active on the board, and she files this as her disclosure. Ms. Sullivan, would you
Yep.
please turn to page 2 of her required disclosures and read the first full question and her answer.
Sure. Do you or your spouse hold any paid or unpaid position with any for-profit entity, nonprofit entity, labor group, or educational or other institution which you have not already listed on this form? And the answer is no.
And the relevance being, although they've admitted, again, they put it in terms of didn't disclose, but when you read that, that is an affirmative denial. No, I am not. And that's a little more serious. This is not a case of, tell me the 10 things you're doing, and oh, I forgot one. I listed 9. Oops. No, this is, are you on a nonprofit board? No, I am not. In the midst of all these emails, and she had to know she was involved. So that's the relevance of that. They've stipulated to this, but it's important to read the actual denial, and it's a sworn statement, which is important too. What is the next document?
So the next document shows the text exchange between the council member and myself. Does everybody have this?
Yes.
Now, Ms. Sullivan, given that they have argued that we took her statement out of context, that when she said, when you quoted her as saying, in my capacity as a board member of this nonprofit, I am working with the investor group with regard to this rezoning request, that's not what she meant. Would you read the whole context so that we all have exactly what the context was?
Sure. So I begin, this is also April 7th, 2026. So this is potentially the night of the third reading of the rezone request by East Bend investors and David Byerly. This is about the time, in the last month, things have really heated up in the community. Hi, Courtney. I hope you'll take a look at the email I just sent to the full council about the East Bend region rezone request. I look forward to hearing what you have to say tonight. Thank you very much. So obviously, I had just sent an email with some of my thoughts. And council member responds, I'm not understanding why we'd be more restrictive of private development than we were of the public land East Bank, which had recently occurred. This whole thing is gross, and behind the scenes nonsense is maddening. And I respond, I think we're seeing the situation very differently. I would be pleased to talk about it more when time allows. I've been watching land development issues in Nashville since the 1990s. I hope that you'll give thought to what I've said in the email. Intent is simply not legally binding. They're going to flip that land, fine by me, and whoever pays for it is going to have very high expectations of what they're going to get in terms of return on their investment if there are very few restrictions as there are now. They will railroad the neighborhood. It happens a lot in Nashville. I have other thoughts about the larger development and what you're saying about behind the scenes. I go on to say, page 5, all I'm saying is the speed of which this thing is moving is not good for any of us, electeds included, except the people who are making the money. Councilmember responds, they're not going to flip the land. I reply, I've been told specifically otherwise, and honestly, I'm not sure that matters. Fine, if they want to develop it, by all means, go for it. But accept restrictions. Don't expect to get everything you ask for because it works in your business interests. Honestly, I think these guys snowed Coupin. You don't want to look back and realize that you were snowed as well. Councilmember responds, laugh out loud, okay. She goes on to say, I've seen the renderings. I'm working with them as a board member of the Children's Museum. I know what's going there and what it's going to look like. It's not going to be flipped, and the people telling you that are lying to you. I respond, once again, none of this is legally binding. That's the issue. The future is 100% unwritten, period. If you want to go on hope, then that's a decision that you're making. But I would respectfully ask you to reconsider. I go on. I think you have a real future in politics, but this will be remembered. Councilmember responds, neither was the East Bank. It will be remembered. I respond, what's the reason? The investors don't want to slow down. People who rush things are usually concerning when it comes to political situations. Councilmember responds, I'm counting on it because they have their money on the line and time is money. That's why. Hello? I say, I'm not okay with the tone you're presenting here, Courtney. Best wishes to you. She responds, me neither. Best to you as well. And the final comment from me is, I've said respectfully, I think I've spoken to you in a professional manner. Do not write me again on this topic.
And again, the relevance of that is simply to say, she said what she said. She meant what she said. It wasn't taken out of context. Now, they also say that that's the whole basis of the complaint. What effect did having her say that have on you, if any, and what did you do next?
I was shocked. As soon as I saw this business about being a board member on the museum that seems to have a strong connection to the East Bend rezone, I felt a duty to look into it. That's the way that I believe we should all operate. I didn't go digging around for this information. It was dropped into my lap directly from an elected official, and so I began to look into it, and what I found was deeply concerning, and that's why we're here.
And when you did your Open Records Act request, did you obtain documents that indicated that beyond your one text, there were other times that she stated that by virtue of being on the board of the nonprofit and the work that
Yep.
that entailed with
Yes, sir.
with the developer group, that gave her some insight into what was actually going to happen there?
Yes, so back to the open records request. Now we're looking at emails between the council member and constituents of East Nashville.
In your packet, it's right after the text that you just looked at.
Looks like this has some red lines. Okay, are we ready to proceed? All right.
Yeah, just
So
briefly
basically,
tell us
real
what
quick,
this
I
is.
can go through this quickly. There are a number of East Nashville residents who've reached out to the council member by email. This is April 15th, 2026, so we're right toward the third vote because there was one deferral. She says in her email response to a East Nashville resident, I've seen the plans as a board member of the Children's Museum. On we go. Another constituent, I sit on the board of the Children's Museum, and we're quite fortunate that the investment group has purchased these parcels. And then at the end of this part of the packet, the council member says, "It's really sad the misinformation that's being spread about this. The East Bend is planned to be a neighborhood complete with the Children's Museum, on which I sit on the board." And then last but not least, after my ethics complaint with Melanie Cochran was filed, another resident speaks out to the council member, and she is talking about, "We've been trying to bring one here for years," meaning the Children's Museum, "and hopefully there'll be one on the East Bend, and the developers are supportive."
The next document that I'd like to hand you, and just to save us time, the relevance of this, it goes to their claim that after that initial introduction, Councilmember Johnston had no further communications as a board member of the nonprofit with the developer group regarding this rezoning or regarding the ability to have a home in the development if the rezoning happened. And also their statement that there couldn't have been a conflict because no actual promise was made to give the museum a home there. I'm not sure I get the logic of whether there was a binding promise made has anything to do with whether or not she was working on behalf of the nonprofit on this same matter that she was voting on. But they say it, and so I want to show that that is in fact not true.
I would argue this is probably one of the most important documents in the packet. It has a 5 at the top and 2 lines over here.
And I'm trying to find it in your packet at the same time.
You're looking for a red 5, and there's a cell number blocked out at the top.
I remember seeing it, but I don't find it in the packet yet.
It sounds like it's toward the end.
4 pages from the end.
Okay. Got it.
Is it okay if I go forward?
Yes, please.
Okay. So what I'd like to do is start toward the end of this page because, you know, how emails get out of order when people reply. So the lower third of this page is an email from Museum Chair Cindy Clinton to the full board. It starts with "Good morning." And Ms. Clinton says, "Good morning. We need to hold a brief 10-minute board meeting today at noon. The update is good news, but important to share with everyone together. If you are unable to attend, please call me or Courtney so we can review it with you." Council member responds all. Now we're at the top of the page. "My cell is blank. In case you need to call in lieu of attending. This will not take long. Please make every effort to attend this brief, very good news update. Courtney."
And would you turn to the next?
So skip the next page, which is 6, and please go to page 7, red 7 at the top.
And this also should be read from the bottom up.
So we're going to go to the bottom of the page. This is where Ms. Clinton is expressing to everyone, "Hi, everyone. Here are the articles I've seen so far." So this is media coverage of the situation. "I've attached a PDF of the Nashville Post article. It's exciting to see the growing interest and momentum around bringing a children's museum." And then if you go to the top of that page, you see that there's an email respond to all from Jesse Brown, who's also on the board, to the full board. "Congratulations to everyone on the news today. And thank you to the board members who've been hard at work in conversations with David Byerly, who's the lead investor for the rezone, leading up to this. I think the East Bend would make a great home for the museum." So clearly, there's been some sort of conversation,
And
it appears, between Cindy Clinton and Courtney Johnston about this agreement, about where the museum will go.
And David Byerly.
And David Byerly.
Now, the next document is a little bit out of order of what you've got. It's got, because it's the
Nashville.
news articles to which Ms. Clinton referred in her email, but in your packet, they're going to come before her email, and it's
So-
got a red number 1. in the top
Nashville
right.
Post article.
And would you, we're not going to read the whole thing.
No, of course not.
Just with regard to their assertion that somehow there can't be an ethical violation because she didn't actually succeed in securing a promise of a home for the museum or whatever the argument is, would you please read at least
Yep.
the quotes from Ms. Clinton and
Yep.
Mr. Byerly?
So near the top of the Nashville Post article, there's 2 red lines.
We had it.
Okay.
It's received.
It says, according to the release, the future MCCM building would sit within the East Bend, a sub-district of the 47-acre Cumberland River fronting scrapyard site.
And would you go to the next page and towards the bottom?
Towards the
read
bottom,
Ms.
of
Clinton?
of the next page, page 2, you see a quote from Cindy Clinton. The opportunity to bring a children's museum to Nashville is closer to reality than ever before, thanks to the tireless support of our many donors and volunteers, and now the commitment of the East Bend team, Clinton said in the release. And at the end of that page, you see David Byerly said, bringing the Children's Museum to the East Bank is a, quote, priority for everyone working on the East Bend.
Would you go forward a few pages to page number 4 and read the actually
Yeah,
longer
so-
quote from Mr. Byerly?
There's a second news article, and you are on the right page with that orange logo. And I'm going to read the full quote from David Byerly of the East Bend team. We have said for years, even before we acquired the East Bend site, that Nashville must create a vibrant and attractive downtown neighborhood where families feel welcome and can build lasting memories together, said David Byerly of the East Bend team. There's no better way to bring that vision to life than by helping make the city's first children's museum a reality. This is a priority for everyone working on the East Bend, and we are thrilled to be working directly with the Music City Children's Museum to identify a location that will allow this important institution to thrive and serve Nashville's children and families.
So to the extent that it matters whether or not Courtney Johnston and the other board members were successful in acquiring a promise of some sort, and I'm not sure it does matter, but to the extent that it does, their statement that they did not get. Now, they may not have got a signed contract, but they clearly were having that discussion, and when you look at the early part, there's clearly been a conversation with Mr. Byerly between the board, and they're telling the rest of the board, if you want to know more about that conversation, there are 2 people you should ask. 2 people can fill you in, and it's Ms. Clinton and Ms. Johnston. So her argument that she was not acting on behalf of the board with regard to the development group is simply false. And Mr. Byerly's statement along the same lines. She apparently was one of the people leading the conversation at this point in time. Actually, let me add that. And I want to be careful, too, about what we are arguing and what we're not arguing. We're not, when you read these emails, it's inescapable that, as a strategic matter, this development group decided to use an inactive children's museum as a very sympathetic prop, and I don't mean that in a pejorative sense, but something to help them get the zoning change that they want. And there's nothing wrong with that. That's really not of concern. And when I say prop, I don't mean that they wouldn't have done it. They very well might give it a home. But they're clearly using the Children's Museum for that purpose. That's not concerning. That's good strategy. What is concerning is when elected officials get involved in that effort and when they're wearing multiple hats, where she's trying to benefit this nonprofit while voting on a zoning change that the nonprofit needs so it can get this home, which is only being done to benefit this investor group that wants the nonprofit. I mean, there's the twisted entanglement, and she's right in the middle of it. Again, after having falsified her involvement. That is more than a failure to disclose. Her answer was no, I am not on a board. So I just want to make sure it's clear.
We're almost done.
Yeah, I just want to make it clear that we're not saying that because a lobbyist communicated a lot with a council person that shows something sinister. We're not saying that because they were clearly, she was helping them use this nonprofit to further their agenda with regard to the zoning change, that's a problem. Well, actually, that is a problem. The fact that they were doing that, the developers, they're not doing anything wrong. She is, because of her multiple roles. Let's go to the next one really quickly. This is a document.
You want to hand me this?
Yeah. Wherever this is in your packet, it has ethics complaint written on it.
You'll see ethics complaints.
I'll see if I can find it.
What do we have left? Just this? And that. We need to wrap up.
Yep.
Okay, very briefly, this set of documents that I'm going to go through very quickly describes an interesting email relationship between the council member and lobbyist Sam Reed. The day that I and Melanie Cochran filed our ethics complaint, it was immediately forwarded to Sam Reed and Sam Reed alone. You'll see additionally, a constituent wrote about this rezone issue, and the council member forwarded that to Sam Reed with the comment, she's a frequent flyer. You'll see that Dave Rosenberg from the mayor's office was writing to the council about some issues, or excuse me, on behalf of Councilmember Cochran, who was wanting to hold a informative meeting, and Ms.
Okay,
Johnson.
I'm sorry, I need to ask you to pause because I can't, I'm still looking for this.
Sure, sorry.
It's toward the beginning,
Yeah.
kind of maybe 30 or so pages.
It's a little bit behind the text messages. Right after the reception page.
I'm almost there, I think.
It says ethics complaint, that'll help you.
I know what it says, I'm just trying to get there. All right, I'm there, thank you.
No problem. Okay, so ethics complaint was sent to Sam Reed from Ms. Johnston the same day that it was filed, and no one else. A constituent writes about the rezone issue. Ms. Johnston forwards that quickly to Sam Reed and says she's a frequent flyer. Next, Councilmember Cochran wanted to hold an informational meeting, and Ms. Johnson forwarded that quickly to lobbyist Sam Reed and says Jacob pandering. There's a message from Dave Rosenberg from the mayor's office regarding the Nashville Downtown Partnership, which Sam Reed also represents. She sends that directly to Sam Reed. Next, you'll see a message forwarded directly from Courtney Johnston to Sam Reed concerning the Downtown Partnership, which I just mentioned Sam Reed is the lobbyist for. There's a message from a Mike regarding stuff going on with security downtown and the Nashville Downtown Partnership, goes straight to Sam Reed. Next thing, same story, straight to Sam Reed. And then we get to an email from Senator Charlene Oliver expressing some concerns about the Boring Company, also represented by lobbyist Sam Reed, and her concerns about that. And the council member sends that to Sam Reed and says, LOL, her criticism of the public comment period could be applied to almost every board or commission, including the Power Board. But she doesn't give a rip about that because that's not the politically charged topic of the moment. Down with Elon, LOL, good grief.
Let me cut your discussion of these short really quickly. To make this quick, the relevance of these. We've got two sets that we're going to be, two sets of these communications that we're going to be submitting. One of them, which comes next, I believe, is a fairly benign, fairly normal set of communications between a lobbyist and an elected official. As Mr. Cooper stated, that happens. That's their job. These are different. If you read these, anytime what these reflect is not simply an elected official working with a lobbyist. These reflect an elected official that anytime she gets a citizen question, concern that might touch on one of his clients that he's lobbying for, she immediately forwards it to him. These show her disparaging.
One second.
I'm sorry to interrupt. I want to allow you to present your case as you see fit, but this is getting to the territory of a closing argument. If you have questions for the witness, it's appropriate at this time.
Well, you know what? If we're going to do closing, I'll stop.
If I could just finish.
Sorry.
At this time, if you have questions for the witness and information you'd like to convey to us through this witness and these documents, that would be appropriate.
Sure.
But the information that you're giving now is an argument about what we've just seen from the documents.
Absolutely.
So if you could wrap that up and get
Sure.
back to the witness.
Yeah, I was just trying to sort of nip it in the bud by kind of saying, here's why we're giving this to you, but I'll do that in closing.
Thank you.
The next set of documents, and these are email set 3.
Let me just talk about it real quick.
Yeah, just
Very briefly, email set 3. And if I could ask, I'm sorry, when y'all are talking, it's distracting.
Oh, I'm sorry.
Thank you, sir. Email set 3, our goal in presenting this information is just to show you how much communication happens between Sam Reed and Courtney Johnston. And I think I can just wrap this up. And what I'll say.
We do need to get these in, just real quickly. Just tell them what this is.
This document with Sam Reed shows that he represents lots of different entities, including the investor group,
And what's after it in that set.
and some financial contributions associated with Sam Reed, and lots of interesting things there. So let me.
Yeah, and the last document is just
Some
the
information about the museum.
Secretary of State filings, just showing that the museum was organized in 2014.
So
That's all, those are all of the documents. I'll weave it together and why half of that is relevant, because some of it's may not jump out at you as why it's relevant. We'll do that in closing.
And the last thing that I would like to say is that I think what is being presented to you from the council member side is that there was not some direct quid pro quo between the investor, Lee, David Byerly, and herself. But Sam Reed is the representative for this organization, and also on the board with Ms. Johnston. We're curious to know how Ms. Johnston got on that board. The investors who want this rezone, they've been working on this project for years, and they've been planning for a long time. That's fine, but it should have been done in an appropriate way without ethics violations. Thank you.
Do you,
I do have a few questions, please.
Oh, sure.
Thank you.
would you stay?
Do you recall when your ethics complaint was filed?
Do you want me to turn around
I've got
backward
it
and
right
talk
here.
to you?
No, I'll come up here, thank you.
Okay, great. Do I recall when it was filed?
Yeah, it was on or about April 15th, correct?
Melanie Cochran and I filed that on April 15th,
Okay, thank you.
2026.
And when did you retain counsel? Because I got notice at 12:15 this morning.
I was told that I should send all of my information to the clerk.
Okay, and you've known your counsel, I assume, for a while now?
A very long time.
Okay, thank you.
Sure.
As you were going through all of this information that you've walked through, did you find any evidence of a contract or an agreement between the museum and the investment group or the East Bend development?
No contract.
Did you find evidence that Councilmember Johnston, in any of these emails that you've gone through so well, any
you.
evidence that she denied her involvement with the museum at any time?
I'm sorry, could say that for me
In
again?
all of these emails
Uh-huh.
where she is, you mentioned several where she has acknowledged her role with the museum.
Okay.
Was there ever a time where she denied her involvement with the museum?
Denied her involvement. Well, she failed to disclose it properly.
Was in any of those emails, did you see any attempt from her to act like she didn't know what was going on with the museum or to deny any involvement?
No, but I would like to note that the.
Okay, thank you. That was-
Excuse
She
me.
has the right to expound on her answer.
My open records request had to be extremely limited. I wanted it to go further, but out of respect for Metro Council's attorney's time, I just couldn't get all the things that I wanted to see. And, sometimes that's just the way it goes.
One more question, and
Sure.
I'll leave you alone. Was Councilmember Johnston quoted in any of the articles that you referenced concerning the discussions between the museum and the development group?
She was not.
Okay, thank you.
Sure.
Any redirect?
I do not.
Thank you. Do you have another witness to call?
I do not.
Mr. Cooper, are you ready to present your case or your rebuttal, sorry?
Ms. Johnston was listed on the witness list. I did not list her because I did not intend to call her. Since she was listed, is it okay if I call her up to ask her a couple questions?
Yes.
All right, thank you.
Ms. Johnston, do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Thank you, Councilmember. It's been well established that you were on the museum at the time you filed that disclosure, which we have acknowledged and you have acknowledged was an error. You since corrected that, is that correct?
Yes.
To your knowledge, is there any agreement between the museum, the Children's Museum, and the developer group for having a location at the East Bend site?
No.
Is the museum or has the museum been looking at other sites besides the East Bend?
Yes.
Does the museum currently have funds available to build a museum if a site was identified?
No. I think we have $15,000 or $20,000 in the bank at most.
How would you describe the discussions or the level of discussions between the museum and the investment group, regardless of whatever PR press the investment group might have put out that was read?
So I brought up the idea that November of '25 was where the whole council was invited. And they were presenting a really nice neighborhood, family-friendly type thing. And I brought up the idea of the Children's Museum. He was open to it. And I since introduced Cindy Clinton. I'm not an expert on children's museums or what is needed or necessary or any of that. And so handed that over to her, and they met. And so the emergency meeting was knowing we were notified that the investment group was putting the articles out that were also brought into evidence. And Cindy and I both thought that it would be in poor taste for the rest of the board to see that in the news, and that be the first time they ever hear about anything on the East Bend, because that's what it would have been. Nobody knew anything about the East Bend because it was just a conversation, an introduction, and a conversation between Cindy and David Byerly and that investment group. And so things were very, very preliminary, but ongoing conversations or any sort of deal or none of that, because the board had absolutely no idea, which was why we called the meeting.
So neither you nor the board was involved in the press statements? I mean, that was not initiated by the museum or by you, is that correct?
No.
Okay. I think the rest of it I can cover in my closing. We've had some conversations about you consulting with counsel. You did ask legal counsel whether you needed to recuse yourself because of your service on the museum board.
Right. Yes, I did.
And what were you told?
I was told that if I was receiving a benefit, that I should, that was basically that it was up to me, but that if I was going to be receiving any sort of personal benefit, that's something that I should consider, and I received no benefit. I've never been paid. Nobody on the board is paid. It's been a very volunteer effort since 2014, especially on the part of Ms. Clinton, and it had no bearing on that site. We all knew that the legislation that we're talking about was going to pass in some form, and none of it would have prohibited the use of a children's museum, so it wasn't relevant to anything being discussed. It wasn't like, is this gonna pass? I mean, it had nothing to do with it.
In fact, the legislation in question included a permitted use as a civic institution, which included or could include a museum, but also included other things like music venues and civic buildings and things like that. Is that correct?
Yeah, nothing in that legislation or in any amendment that was brought forth would have prohibited the use of a children's museum. So it would always have been.
Okay.
Okay, I have a couple of clarification questions. So I want to ask a little bit more about your, I don't want to get into the actual conversation necessarily, but when did your conversation with Metro Council take place? With Mr. Wilson?
I mean, the specific date, I don't remember. It was approximately around that third vote.
Okay, what month are we talking?
April, April.
26?
Yeah, sure. After the ethics complaint, which was like,
Okay.
exactly.
Okay, understood, thank you.
Sure.
So you were identified in the materials that Ms. Sullivan submitted as the chief advocate for the museum and the development. Is that an accurate statement?
I believe so.
Is it an accurate statement to state that you are or were the chief advocate?
No, the chief advocate of the Children's Museum has and always will be Cindy Clinton, she retired from being a teacher to push this forward and start this organization in 2014. And actually, I was contacted in 2021 and have been an advocate and a supporter of the Children's Museum since 2021.
And you were contacted in 2021 because there was a potential site in your district?
There was a building, there was a building in my district that they were looking at, and so they wanted to talk to me about would I be supportive of that use. It was on Sidco, and so I've been a supporter of the project. I mean, I think it'd be wonderful to bring a children's museum to Nashville, and so was absolutely supportive of that.
Okay, thank you.
I have a few questions. Okay. One, Councilmember Johnston, when were you asked to join the Children's Board and who asked you?
It was sometime in 2025, I think. I mean, I know it was sometime in 2025, I just don't know necessarily when. And it was Miss Clinton.
And had you had a relationship with Ms. Clinton before then?
Yes, I've had a relationship and been a supporter of the Children's Museum, like I said, since 2021 when they contacted me.
Okay. And at the time that you were asked to join the board, was Mr. Reed already a member?
Yes.
Had you spoken to Mr. Reed about his service on the Children's Museum Board or interacted with him regarding that topic?
Yeah, we've talked about the Children's Museum and how to fundraise and help get it off the ground, certainly, but not anything else. I mean, I don't know. I mean, we've talked about, Sam and I have talked about the Children's Museum, yes.
Okay. And the Children's Museum, as I understand it, was incorporated in 2014, right?
Yes.
What activities does it engage in at this point since then, or relevant from that period till now, anything significant that they've engaged in?
I know Cindy has worked really hard to gain some support and some awareness around her desire to bring a children's museum to Nashville, and also finding a site. there is no children's museum. And the first thing you need is either a building or a site to build a building, and then what you need is money to pay for that. And so she's had significant trouble finding a place. Nashville's quite expensive. And the size that you would need to be able to grow into it, it's just been really difficult, obviously, because it hasn't happened as of yet. But that's been their main thing, is finding a location.
Yeah, she basically asked my questions. I guess, can you describe a bit about since 21, when you first were approached by Cindy about the Children's Museum and the possibility of placing it within your district, and 25, any involvement with the Children's Museum? Were you, can you describe your relationship with Cindy about the emergence of the Children's Museum?
Yeah, we've just stayed in touch and really become friends, but I've always just been supportive of that project to bring it forward, whether it was in my district or not. And so we've talked about different locations, we've talked about, just that. I mean, it really has been focused in on, we have to find a location because we have to have a physical location for the museum.
Right. But none of that effort between 21 and 25 involved metro zoning or planning or anything?
No.
There was never a issue that came up that
No.
became a
No.
question of regulation, okay.
Can I ask a question?
Yeah.
Other than with the Children's Museum, have you served on other boards?
No.
Are you aware of other council members serving on boards, and have you talked to them about this type of disclosure?
No. And that was another thing, when I filled that out, I'm thinking in my brain, and it's not an excuse, it was a mistake. I did say no, and the answer was yes. In my brain, I'm thinking, what am I benefiting from? My husband and I used to own short-term rentals, and so it was, where are the locations of those things? What businesses, what LLCs, those types of things. That's where my brain was going. And so it really was an oversight. And so as soon as the ethics complaint was filed and I realized that, I immediately corrected that disclosure. If I meant to try to hide it, I wouldn't have told it to people. I've always been pretty upfront about my support for the museum and to bring it here. My picture was apparently on the website. I never saw it. So it wasn't a secret. It was just an oversight that was corrected immediately.
I have another question.
Yeah, okay.
My understanding is that you're no longer a member of the Children's Museum
Correct.
Board. When did your service end?
When the ethics complaint was filed, I felt like it was, at that point, a distraction to the museum and counterintuitive to the mission there, and I don't want to be a hindrance to anything, and I just felt it best to step away.
In 25, when Cindy asked you if you'd join the board, you said yes.
Yes.
What was the thinking on a potential location in the area of the East Bend at that point, sometime in 25? What was Cindy thinking about the potential for putting the museum in that location, the scrapyard?
No, there was nothing in 2025 then. I didn't meet David Byerly or know anything about East Bank until November.
Of 25.
Of 25, right.
Okay.
Yeah, and then.
You agreed to be on the board before you understood there was any thinking.
Well before, yeah.
It could potentially be cited on this, in the scrapyard.
Absolutely, absolutely.
Well, wait, that confuses me, because in the April 2026 text exchange, I'm sorry, I apologize, never mind, I fixed my own confusion. Thank you.
When did you first learn that the museum was thinking that there was a potential to connect? When did these two things become connected in your mind? When did you first realize that the siting of the museum could be theoretically, potentially on this East Bend? I don't remember when they purchased the land, when they started talking about what they were going to do with the project. I don't remember which.
It was early 2026. We had that reception, I think, in November, and I mentioned it to David and said I would love to introduce you to Cindy Clinton. That introduction happened. They met. Once it really became, hey, this could possibly happen was when the articles came out. It was like, hey, this is making this real. This is really exciting that we're getting some traction, just as Cindy said in her email. So it was in, spring of 2026.
So the board of the museum and Sam Reed hadn't ever raised the idea that the museum could potentially be sited in this scrap metal that was, this scrapyard that was going to be purchased and redeveloped. Sam Reed from the board, in the board meeting, never said, hey,
Sam
maybe.
doesn't come to the board meetings. So I don't know what he was very focused in on this legislation, I will say that. So he didn't have anything to do, if he had conversations with David Byerly, I can't speak to that because I don't know what conversations would be held outside of me. All I know is that I made the introduction to Cindy.
Okay.
They met and talked, and then the article, we were told that the article was gonna come out. The board had absolutely no idea anything about the East Bend until the articles came out, and that's why we had that emergency meeting to let them know, so that, just out of courtesy, so that it wouldn't come as a surprise. As a board member, we felt like they should know.
Sure. But I mean, the first time these two things came together in your head was when you introduced, David Byerly. In November 25, when you realized they were going, I guess it was a presentation of the development on the East Bend, right, to all council members.
Yes.
It was, so all of a sudden you see
Just
this development, what the zoning was, they were going to be looking for. You realized, hey, that could be a site for the museum.
Pipe dream, actually, knowing that it was,
But at that point, you were going to introduce him to Cindy, and put the two pieces together.
yes, and I think they met in March.
Okay, but as of November, you understood that the East Bend zoning would be coming to you as council member, and you were on the board and would be interested in enthusiastic about finding a site and a home for the museum that you've supporting for a few years. So at that point in November, when you put the pieces together, that's kind of when you began to see that maybe there's you have a council member role here, but there's also your board member. That was really the first time, November of '25. I mean, not a moment before that. That was the first time you realized, hey, these two worlds of mine, I'm hearing about the development in the East Bend because as a council member, there's going to be zoning issues. And is this good for Nashville? Is this good for the community? And you also knew, hey, pipe dream, but maybe finally, after all this time, the museum could be sited in that same spot. That these two things you care about, council member responsibilities and siting the museum, kind of came together in that November 25 meeting. And that's when you said, let me see if this could possibly happen. And you made just a simple introduction and things took off from there.
What was said was he was open to meeting with Cindy at that November meeting, and then it was months down the line.
I understand, okay. But he was open to meeting to potentially place it there, the museum, in the rezoned scrap metal.
He said he was interested in talking about it, that it fit in with what they were doing, being family-friendly oriented type development.
Right.
So I was happy to make that introduction.
I understand, thank you.
Yeah.
Councilmember Porterfield, you have a question?
Yes, thank you. I want to make sure I want to see if I understood this correctly to Mr. Cooper. Good to see you. Did I understand the question to Councilmember Johnston? Was the question about if the museum was going to be built? There was a question that you asked about, like, something, and I feel like Councilmember Johnston may have said something like the museum's not going to be built, or there's not money to build the museum. I want to make sure I understood that question.
I had asked her kind of what the status of building a museum was and whether they were looking at multiple sites, and her answer was that they are still looking at multiple sites and that they have not raised the money to build a museum. So essentially, it's an idea at this point.
Okay, thank you. And then the second question was, there have been a few references to something where all council members were invited to a presentation in November. Is that based on the printed email that we have here in this document?
Correct, that lists all the council member email addresses,
Okay.
or multiple anyway.
Yeah, I was gonna say that, I just wanted to be clear for the record that all council members are not on this particular email. It looks to be about 26 council members. So I just wanted to kind of like state that for the record, because we keep speaking into the room that all council members were invited to this event. It looks like there were about 26. So I don't know that that has any bearing on anybody's case, but I just like facts. So I just want to make sure that's out there.
How many council members are there?
40.
So were all council members invited?
We don't know. We didn't send the invitation out. I don't know.
But Ms. Johnston, or Councilmember Johnston was invited,
Yes,
and did you attend?
yes.
And that's where you introduced David Byerly and...
No, that's where I mentioned to him the Children's Museum and wouldn't this be a great fit and would you be open to a conversation? I would love to introduce you to Cindy. And he said, absolutely. And then it was months down the line before the introduction actually happened. I think they met in, I don't know, March or something.
Okay. I have questions about the emails, the series of emails that you forwarded to Sam Reed. What is your relationship with Sam Reed other than he's a lobbyist, you're a council member, and you're both board members of the Children's Museum?
That's it.
So why were you sending him those emails?
Because anytime there's a concern that is brought forward, I'm gonna send it to them so that they can address. That happens with any lobbyist, really, on any particular development. When someone brings a concern, I think the team should know about it, so that they can address it.
I won't be able to find it, but I remember looking through the PDFs and seeing some exchange where you forwarded something, I believe it was to Mr. Reed, but I could be mistaken, and it was a question that said, should I do this? Do you remember that, seeing that in these documents?
I saw it.
Okay.
In reference to an event from the chamber. Malik from the chamber sent the invitation, and it was a question to Mr. Reed, should I do this?
Why were you asking Mr. Reed if you should do something with the chamber?
Because he's got a pretty close relationship with the chamber, and so that's like, is this a waste of my time? Should I go? Should I not? Type thing. He's usually got a pretty good pulse on what's worthy of. I mean, we get invited to quite a few things, so it's helpful to not go to things that aren't helpful.
Do any other board members have questions for this witness before cross-examination?
I have one other question. So, from what you've said, it makes a lot of sense why Ms. Clinton had the knowledge that other board members didn't, and why she should be sharing this information in March after the news articles were about to be released. Why were you the other board member that had?
Because I'm the one that made the introduction.
What was the, when Ms. Collins, is that right? Ms. Collins? Clinton, I'm sorry. When Ms. Clinton sent the email to the Children's Museum board members and said, we have exciting news and you can ask me or Ms. Johnston about it, what specific information was it that you had for the board members at that time?
That the article was gonna come out and that East Bend is a possibility because they were interested. Yeah.
And you and Ms. Clinton got that information from whom?
David Byerly.
So you were discussing the...
No, Cindy let me know. They had their conversation, it went really well, and then the news article was gonna come out, and Cindy felt like having an article come out about the Children's Museum without letting the board know first, they should know first. That's what it was. Hey, this article's gonna come out. She's had a conversation with them. This is along the lines of what this development is looking at, is family-friendly type stuff. And so we're excited to have these conversations.
I think the question they're trying to get at is why would, I was calling her Cindy because I couldn't remember her last name, Ms. Clinton. Why did she let you know the results of her conversation with Briley before she let everyone else know? the other board members.
She called me about the article coming out. So I knew what was in the article.
Why did she call you about the article if she, I think the problem we're having is a hat problem.
Because nobody else knew that any of those conversations were happening. I knew that they were meeting because I made the introduction.
I see.
If she was to have called another board member.
Out of the blue.
Out of the blue, that was the whole point of having the meeting, is we don't want this to come out of the blue for you.
You and Ms. Clinton knew that there was some movement by the museum to try to get a location in the East Bend. You had you introduced them, you knew she was going to be speaking with him. Did she update you on when she was going to be speaking with him?
No.
So just at some point you got a call and she said, hey, good news. I thank you for the introduction. We did meet and he's open to the site. In fact, he's going to talk to the press.
Well, and I
about
think
it.
the article came as a surprise to her too. And to their point, it probably was for PR for them. I get that, from a strategy perspective.
Right.
Yeah, and so that sort of came out of the blue too.
So the article and the development group being open to citing the museum there, she wasn't, after you made the introduction, did she confirm that they were going to have, they had a plan to talk? We're just really trying to understand the communications that happened after November 25th event, and the article, and the contact, and the email from Ms. Clinton telling the board, hey, be in touch with me or council member. We're trying to figure out any communication during that period, from November 25 to whenever you were told that the development team was open to giving the museum a space.
Yeah, she said that they met and that the conversation went well.
She told you.
Yeah, it was just an initial.
They met and it went well.
And it went
That's
well.
all you knew.
Yes, and then the development team had the idea to go, right.
Got it. Okay, so when did she tell you that it was looking good? That they had met, she and Bridley had a communication, and the development group was open or is looking good that maybe it would be cited in the East Bend. So that was sometime after November 25 and before April.
It was right after their meeting, which was.
March was when the
Yeah,
articles came out. So somewhere in there.
Right, it was right after their meeting.
And you think that was when?
It was either February or March. I would have
February,
to-
March. So in February or March, you knew that the museum, that there was some openness to the museum being cited in the East Bend. At that time, what was happening in council with this project?
They were discussing multiple amendments. There was an expansion of the DTC code, which the DTC is what is East Bank. And so they were expanding that because of the scrapyard needed to be rezoned to allow for that. And so they were looking at different amendments to prevent however many hotels and how many this, how many that. Had nothing to do with whether a children's museum could have been there or not. It was literally, I mean, that was going to pass in some form, no matter what. I think everybody's excited to get rid of the scrapyard and make that be something that people can enjoy. And so it was going to pass. It was just, is it gonna, and the concern that we were getting is it gonna be, downtown 2.0, Broadway 2.0, which was not what was presented to us in November. It was never what was presented. And so the amendments that were coming forth were literally number of hotels, how big of this, walkability, all of those things. It was just, refining what that land use was gonna be, but it was never gonna prohibit a children's museum.
It sounds like you're kind of saying, it sounds like you're describing that in your thinking about it, they were really discrete because there was no impact. One wasn't impacting the other,
Correct.
so it was discrete concepts.
Correct.
This is this, and this is this.
Correct.
Two different things.
Correct.
That's
And
how
I
you
would
understood
have,
it.
yes, and I would have voted yes for that anyway. I mean, I think everybody's thrilled to have that area be developed something other than a scrapyard. And so the specificity on the different, how many hotels or whatever, that's minutia compared to the overall, this is a good thing, this bill is a good thing for the community.
I don't mean to belabor this too much, but I have one more question. before the articles came out, where Mr. Byerly was saying he was excited about the possibility of the Children's Museum being there, had you had discussions with any other council members about the Children's Museum possibly being in East Bend?
And that was not part of the legislation, correct?
No.
There's nothing about a children's museum?
No.
Did you at any point discuss the possibility of the Children's Museum being in East Bend with your fellow council members?
No.
Cross?
Yeah, one moment, please.
Okay.
Ms. Johnston, are you contending that you and Sam Reed never had any communications or conversations about the rezoning effort?
He sent me information, just like he sent any other council member information about his, according to his efforts as the lobbyist for that particular development and that bill.
You said that you consulted an attorney. Well, actually, before I get to that, I want to hand you a small set of the emails that are you forwarding anytime someone had a question or a complaint involving Mr. Reed's lobbying clients. And for everyone's convenience, this is the one that it starts with ethics complaint, which she forwarded. This is not the bigger set, which is just the generic lobbyist emails, but the ones more specifically. So if I understood your explanation as to why you were forwarding to him every time someone raised a question or had some objection to something relating to one of his clients, including this investor group, you said that just as a matter of course, if someone's raising an issue, you feel like it should be forwarded to the lobbyist working on that matter? Or I don't want to put words in your mouth. Tell me
That's
what
our point of contact. The lobby, for any development, we typically don't, that's who we deal with, is the lobbyist. And so if that's an issue that is a valid issue, it should be communicated so that they can address it, whether they need to correct it or with legislation or assuage people's concerns with whatever communication.
So, if we were to do a broader Freedom of Information Act request, are you going to tell me that any time a resident of Nashville emails you about an issue, you will have forwarded that resident's concerns to whatever lobbyist may be representing a party interested in that matter?
Not if they're duplicative, typically.
What do you mean?
Well, if we have 50 people that are saying, we're concerned about X, I'll probably forward one, maybe two, and I may say, we're getting a lot of these things, but I'm not gonna forward every single.
I understand what you mean, but every issue and every lobbyist, you're contending this was not a special relationship in any way. You did this with every lobbyist on every issue when Nashvillians voice concerns.
Typically.
How many emails do you get in your inbox, your Metro inbox in a month, just on average?
It varies. Sometimes it's a ton of emails when something's going on that's of concern or a big development, and sometimes it's very few.
But is a ton like 20 or is a ton like 200?
It depends. It depends. Sometimes
Average
it's
out.
20. I can't average it out because there's the types of developments that people care about run the gamut. Sometimes it's very hyper local sensitive to things and sometimes not. So you can have a development in North Nashville that the area in North Nashville will send, and you'll get 20, 30, 40 emails, and sometimes it's countywide and you get hundreds.
Mm-hmm. And in every case, you figure out who the lobbyist is that's interested in that issue, and forward at least a representative sample to that lobbyist?
Typically.
Okay. When you do so, do you just silently forward it like you do, or is it typical for you to mock and belittle the people who are raising those concerns?
What is the relevance to?
The relevance, do you want me to explain the relevance? I don't want to make a closing argument here, but
Go ahead.
the relevance is there are a lot of emails that are just typical lobbying activity, and then there are some that are different. There are some where clearly this is someone who feels a duty of loyalty to help this lobbyist and his clients, including this real estate development project. Because these aren't just forwarding stuff. This is also belittling the concerns of people, mocking them. Do you do that when you forward with all these lobbyists? And don't take my word for it, the belittling statement. Let's read it. You have, for example, there's an email, I don't want to say her full name, though it's in the document, from Michelle, let me find it.
It's that one.
Okay.
And I said frequent flyer, meaning she is at
Constant complainer?
most, no, she's at most frequent flyer, meaning she's at pretty much every single council meeting.
But you didn't mean that in a dismissive manner at all, saying, she's a frequent flyer.
I'm a frequent flyer to certain restaurants. That's not necessarily belittling. That means she's involved and she shows up to meetings quite often and is very vocal in her thought processes around what's going on.
And when Senator Charlene Oliver wrote something about how asking for oversight over Elon Musk's boring project is not the same as obstructing it, and you wrote all this about LOL, she doesn't give a rip about these other similar situations because it's not politically charged. Is that typical of what you say to lobbyists when you...
I don't understand what this has to do with an ethics complaint about
This is
whether I
about
voted or
relationships.
not on.
This is about relationships.
I have relationships with lobbyists, and every single council member does as well. That's their job, is to have relationships with us.
This is about the nature of those relationships. This is about someone who clearly feels it's her duty to work for this lobbyist and his clients. That's why I'm asking you this.
Absolutely not.
Let's get back to the question. I don't want to argue with you. Let's get back to the question. This sort of belittling and diminishing of what Charlene Oliver wrote, is that typical of what you send to the lobbyists when you just informationally forward them what you're hearing from the public about their projects?
I don't know.
You don't know? I mean, I'm asking you what you write. Surely you know.
You see what I wrote. I have opinions about other people's opinions, certainly. Don't we all? But I still don't understand what this has to do with me voting on a bill or not.
So I just want to ask, since we're on these documents, and this is just, I don't know if you're going to go there, but just the discussion of forwarding to Sam Reed constituents' concerns, but there's also two in here that were other council members. So I didn't know if that was a different animal
right.
or not.
So, well, let's talk about that.
I don't know if you're going to get to that or.
I wasn't planning on it, but that's actually a very astute observation. Just,
There's a.
so in this same set, it appears that Jacob Cupin, council member, correct? Is wanting to organize a conversation, a discussion with the public about something relating to the Nashville Downtown Partnership. You see that?
This is a different MOU and a completely different piece of legislation, correct?
Yes, this is not the real estate project. This just goes to the nature of your relationship with the lobbyist, Sam Reed.
Who represents the downtown partnership.
Who represents the downtown partnership. So, but have I correctly characterized this, that this is Jacob Cupin just wanting to set up a public conversation with residents of Nashville regarding something relating to the downtown partnership, correct?
Yes, it's related to the downtown partnership, who is represented by Sam Reed, and I forwarded it on.
And you forwarded it to Sam Reed, as you've explained already, which is your practice to do to keep the lobbyists updated about concerns about their projects, right? Is that what you said earlier? But yet you characterize, Jacob, wanting to invite public conversation as pandering. Again, I just have to ask you, is that typical of what you say when you just give this information to these
What does
lobbyists?
that have to do with me voting
I'm
on
asking you
this
questions, ma'am.
particular
Ma'am, just
ethics
answer my question.
complaint?
If I could interject, if your attorney has an objection, he can make the objection, but otherwise you should answer Mr. Peter's questions.
I object to the relevance of this entire line of questioning.
And I will respond. The relevance of this is what these documents show is this is more than just the normal communication between an elected official and a lobbyist. This is a lobbyist and an elected official who both serve on a board together for an entity that will benefit if particular zoning changes get made. And there is a pattern of any time something comes up with regard to his clients, she forwards it to him, but she doesn't just forward it to him, as she explains that she claims she does with every issue. She clearly sees herself as on Team Sam Reed. This is not simply informing him. This is mocking and belittling the people who dare to ask questions, who dare to just invite public conversations, in Cuban's case, about his client's desires. This is a relationship that goes beyond normal elected lobbyist relations. That's the relevance.
So the question, as I understand it, to you, Councilmember Johnston, is whether this is a representative example of how you characterize emails when you forward them to lobbyists, other lobbyists besides Mr. Reed.
Usually it's a simple forward. Sometimes I have commentary.
And in Mr. Reed's case, you have commentary sometimes about his projects.
Yes.
Are there other lobbyists where you have that type of relationship where you have these comments about things that you're sending them?
Certainly, most all of them that lobby the council.
And Mr. Peeper's question was, like this email where you forwarded and said he's pandering, is that typical for you to characterize another council member's efforts in that way to a lobbyist?
Sometimes.
And is it common for you if a council member reaches out to all council members for a council member discussion to forward a council member's request for council member discussion to their lobbyist to whom it's
So that's
relevant?
actually, it was on our public forum.
Okay.
And so I was forwarding it to let him know, hey, this conversation is going to be happening probably, and so you should know about it as the representative of Downtown Partnership, because it was asking certain questions. And so if this is if these are questions that the Downtown Partnership or you as the lobbyist need to answer, I mean, that's the nonverbal purpose of sending that on. But it was public information because it's on Council Connect.
Okay, and then when David Rosenberg out of the mayor's office, that was his email to vice mayor and members of council. That was also, again, that type of thing you would just forward to the relevant lobbyist, even if it's from the mayor's office. David Rosenberg is legislative affairs, and you would just think about who it was relevant for, what issue are they talking about, and send it to the council. That was
Yes.
a common practice of yours.
Yes.
Okay.
In that context, even accepting that explanation, why would Councilmember Cupin's mere invitation to have a public conversation about a topic on which Sam Reed was interested as a lobbyist strike you as
Objection
pandering?
relevance.
Same relevance. Why do you consider that mere act of wanting a conversation with the public pandering?
I don't think it's relevant why she thought that was pandering. it's more relevant that she thought to tell this to the lobbyist, but I don't think beyond that it's not relevant.
Okay. I just want to ask you a quick question, and this might be my last question, although I do want to check with Ms. Sullivan. You said that you consulted with Brian Wilson, the Metro attorney, what, just before the final vote? Before the third passage of third reading?
I think so. It may have been second reading. I mean, I can't.
Okay. When you explained to Mr. Wilson the nature of your involvement on the board of this nonprofit entity that would benefit from the zoning change, the nature of your relationship with, if any, with the development group, particularly its lobbyist, Sam Reed, did you provide Mr. Wilson with any of these emails that we've been talking about?
He was aware of the ethics complaint, so he knew about what was being accused. And so his response was, if I'm receiving a personal benefit, that's something that I should consider. I don't receive a personal benefit from any of it.
But again, the question, well, he was aware of the complaint. So it was after the complaint was filed that you consulted with him?
Yes.
Okay, so anything you did prior to the complaint being filed, so in other words, all of the subject matter of the complaint, you cannot claim protection of advice of counsel, correct? Because you got that advice of counsel after the complaint was filed, correct? You just said that.
Correct.
Okay. And even in obtaining that after the fact advice of counsel, he was aware of the complaint, but the complaint didn't involve any of these emails showing this kind of relationship between you and Sam Reed, did it? Do you have any reason to think that attorney you consulted with knew about this kind of interaction between you and Sam Reed?
I think council is aware that council members speak with lobbyists all the time, very frequently, about everything.
I didn't ask you if he knew that you frequently speak, even regularly speak with lobbyists. What I asked was, did you, in providing him the information to obtain that after the fact anyway, legal advice, did you provide him with documents like this that would show what the relationship was that you were asking about?
That wasn't what I was asking him about, my relationship with Sam Reed. What I was asking him was, do I need to abstain from this vote because I have a conflict of interest? And the answer that he gave to me was, if you are receiving any sort of benefit from this, then maybe you should consider that. I don't have any personal benefit, regardless of my relationship with a lobbyist on that bill or not.
Okay. So, and don't let me miss, please, if I say this wrong, tell me how. So if I'm hearing you right, you asked him whether, simply by virtue of your position on the board of the nonprofit and this being voted on, whether that required you to abstain. Is that what you asked him?
I would have to look back at how I asked him. He knew that the Children's Museum was a possibility on East Bend, and I'm on the board. Should I abstain from some sort of conflict of interest? He said, if I am benefiting from it personally, and I am not benefiting from it personally. I have never been paid. Nobody ever asked me well,
Sure.
The lobbyist asked me
We've not,
to
yeah, and we've
vote
not
yes.
put on any evidence that you were paid or any of that, or that money went in your pocket.
Or that anybody asked me
Gotcha.
to advocate on behalf of at all.
Okay. So you obtained this legal advice that you could vote without abstaining prior to the final third vote, correct?
That passed 37-0, yes.
Right. But so even presuming that somehow advice of counsel protects you from the violation, you had already previously voted on this bill, correct?
Yes.
On prior?
Yes.
Okay. I think that's all I've got, but I want to talk to Ms. Sullivan if I can.
Real quick, No, I'm sorry.
Oh,
You
sorry.
can't ask questions to the witness. You
well,
can confer with your attorney.
Well,
Okay.
just tell me and I'll ask.
Chair,
That's it.
while they are conferring, would it be appropriate if I have a question for Ms. Sullivan's attorney, would it be appropriate to ask that at this time?
Okay.
That's all I've got.
Okay. You have a question?
And I'm so sorry, I forgot your name, Miss Sullivan's attorney. I
Oh,
forgot your name.
Peeper.
Okay, Mr. Pieper. I just have one quick question about one of the documents that y'all have submitted. It's the email that is labeled as MNAA issue, and it is an email between Councilmember Johnston where there appears to be someone who's up to be put on the airport authority, and Councilmember Johnson emailed the personal reference asking about the person's residency, legal name, and about their like DNA badge. And then it shows Councilmember Johnston forwarding this information. Y'all didn't speak to that, so I'm just curious as to why that was included. Was that included just to show like the relationship between the council member and the lobbyist, or was there another reason that was included?
Well, it is, I don't think the content of it itself, whether this person should have been on the airport authority, is relevant. But it does just show more of a working relationship that goes beyond just a typical elected official and lobbyist.
Okay, thank
And
you.
again, I would fully agree with what Mr. Cooper said earlier about there are going to be volumes of communications between lobbyists and elected officials. I mean, we know that, and that's not unusual or problematic, but it's the nature of some of these that show something went above and beyond.
Thank you. I was just trying to understand.
And one quick question to the council member. Your conversation with Attorney Wilson was person to person, oral,
No.
phone, email, text?
I think it was email.
Email, okay. Where you asked the question and he responded?
Yes.
So there's an email to that effect, okay.
Do any other council members have questions for this witness? Do you have redirect? Do you have any other witnesses to call?
No.
Ms. Sullivan?
When you're ready, I just think maybe a bathroom break might be in order.
Oh, yes,
Okay, thank you.
Yeah. Okay, so we're gonna take a bathroom break and then we'll proceed to closing arguments unless there's anything else as part of your presentations. Okay, let's do a 10-minute break. Has to leave before we wrap up, do we lose quorum?
No, we'll still have.
Okay.
Yeah, because of the election.
They canceled the, okay.
I don't know, well, I don't know if they
Did they cancel
canceled,
it?
I don't know.
Okay.
All I know is they pushed us to the 20th.
Dang, okay. And Freddie out here saying we're gonna eminent domain.
That's crazy. I saw that.
That's wild.
I knew they had been talking about that, but they had said last week that
Oh, good.
they didn't think it was a viable option, and then this morning I was like, oh, well, we'll see.
get?
I took the bus.
You need one?
No, I took the bus, thanks.
I'm good.
Yeah, I hope so.
Glad you, I know.
You need one?
Thank you.
If they would charge y'all to park here every day, that would be crazy. It is Nashville after all.
Did they all get
Sure.
everything they needed?
I feel like I don't know what you think, but like the telecom feels a lot more restrictive from like what they could try to build there if they get.
That's my appeal.
Yeah, that's what I'm saying, is like, I think makes a lot of sense.
So I'm hoping we can make that argument.
Is John gonna be there, or who's gonna be there with you?
Bill Herbert. So we merged.
Oh, you brought them together?
Yeah, we
Oh, okay,
merged them
okay.
together, yeah. So the 20th, it was on the 6th,
No, she's
and then the election or whatever is, so I don't know if they,
20th of July.
no, August.
August.
At the 11th hour. 'Cause this weekend was like review all this shit.
Maybe we'll honor by then.
I was about to say.
Yeah.
You know, I mean, I was aware, I'd listened to it, but I didn't really dive in.
It had the,
Has that ever,
had the
have you ever seen an
feeling
eminent domain?
which I guess we can.
I've really only seen it from
I mean, we
Metro
didn't- she'd be
for like right away.
Yeah.
There's a big difference in a week and the evening before, I get that.
Other stuff.
But,
Maybe for like schools.
goddamn, made for a
In Metro, I
miserable
haven't
weekend.
seen it. I don't
Much to
think.
digest.
Apparently it was used well in
other
the access
information?
story. It said
Well, actually, what happened?
in the 90s, I guess, to get the land for Music City Center. Which was
Oh.
just like a bunch of parking lots. I think it was like,
Yeah, sure.
There's a lot of parking lots, let's just take them all up, you know, if Metro can take it, we got better use for it.
That was before my time.
the state, I guess. I don't know how they're gonna, I'm talking about the choice lane thing, well, you know, like all those buildings they're gonna have to buy. But like, I feel like that makes the project twice expensive.
I mean, ultimately, it wasn't like that many properties, was it? It was like 2,400.
Well, there's a bunch of commercial properties, and some of them are like,
expensive.
one of them's a freaking hotel, like 30 million or something. Even if it's like kind of junk, it's not
Well,
cheap.
private partnerships, you know, makes sense. Kind of
It's like how, like,
so
when I
much
saw,
money, yeah.
when I saw the list of properties, I was like, I mean, that's gotta be $100 million. Just to tear down stuff.
Didn't they say they're gonna go back and like look at it again?
Yeah,
Have they
I
come
know.
back with it yet?
Apparently they got their approval, but that's not really related to eminent domain.
In Texas, like Austin, all those places, they fought really hard against highway expansion because they were just, you know, eminent domain in so many neighborhoods. But here it's just basically the ones around.
Where the exits are.
There's some places where it's built so close, like closer to Murfreesboro, like small.
Salty.
To make it.
There's neighborhoods that are like right on the street there. And I was concerned like it was gonna be basically the whole way, but I guess there's enough.
Guys, I just wanted to let you know that the mic is hot here, so
Okay.
you're being broadcast on.
Okay. I'm not gonna say anything. You're crazy.
This is my lack of giving a lunch break, the reason we're gonna get snacks now. Just in case, that's very kind.
Because you all supported that.
No. I think it's still kind of up in the air.
It's like it's been a while, but you know, summer, but you all have no idea.
Yeah, it's probably like a pack. I'm guessing. And what they've done with them before is understanding they had two guys that would play both of them for the first like 3 weeks.
Never mind, too long.
Like alternate quarters or whatever, especially if it's some cupcake game. And just like let someone win it. Or at least like not have to be the bad guy and say like, just say like,
You play worse.
this other guy's better. That would be fun.
It's P-I-E-T-E-R. First name Brian with a Y. And if I were a better lawyer marketer, I would have a card.
Brian, B-R-Y-A-N?
Y. You're Y.
Okay, thank you.
I had already grabbed one. Okay, we are back from our break and ready to proceed with closing arguments. Where the complainant, attorney can go first. Mr. Peeper?
I have a quick question. Is the decision going to be made today, or how does that get handled?
Yes, we'll deliberate after everyone concludes their case and arguments.
Okay, thank you.
This is going to be very short. I'd like to end where we started. What are the standards that we contend she violated? And these are 2.222.020 K, O, and Q. A council member, I'm adding that just for context, shall not give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties. That's K. O, council member shall not engage in any outside activities which might impair their independent judgment in the performance of their public duty. And then Q, council member shall not personally represent the private interest of another person or entity before the Metro Council. Now, they've made a lot of arguments that don't go to those standards. Does the fact that she served on the board of a nonprofit that would benefit from a zoning change while advocating for that zoning change in the Metro Council, does that give a reasonable basis for the impression that she could be improperly influenced? Absolutely, without question. Again, it doesn't have to say that she was influenced. It doesn't, that, you know, they say she wasn't influenced, it didn't affect her vote. They say, well, she wasn't actually paid for it. We didn't explicitly engage her to do that. Doesn't matter. It's the fact that she did it, the fact that she occupied both of those roles. And I would argue was actually representing the interests of the developer as well, because that's why the museum was involved in the first place. Does that dual role, is it an outside activity that might impair her independent judgment about whether this zoning change should happen? 100%. I don't know how in the world, with a straight face, they can deny that one. Do these dual roles constitute her representing the private interests of the nonprofit? And again, I would argue the developer as well. Absolutely it does. Absolutely, she is advocating, and it's not just the vote. They keep focusing on the vote. Yes, the vote's important, but it's also every email she sends advocating for the passage of this rezone. And they make several arguments that, again, move the goalposts. They say, well, there never was an actual contract or binding agreement between the museum. I don't see that fitting in the elements of any of those three provisions. That's irrelevant. The fact is, she promoted it, she advocated it vigorously, with or without an ultimate binding contract. They argue that, well, whether or not the museum would be in this location was not part of the legislation. No, but it was, their ability to be in that location was contingent upon the legislation passing. So no, the Metro Council wasn't voting on, technically, whether this museum gets to be there. But they were voting on a zoning change without which the museum could not be there. They argue that, well, her vote wouldn't have made a difference anyway, because in the end, it was unanimous, but not initially. It went through many changes, which were hard fought by the very people she was ridiculing in her emails to Sam Reed. And so, and again, when I read the elements of these three provisions, I don't see anywhere that it says, but only if her vote ultimately would make a difference in the outcome. That's not, we don't need to establish that to establish these violations. It's irrelevant. And then circling back, finally, to the false disclosure that she filed. They repeatedly have stated, well, in these emails and texts to residents, she didn't deny her involvement with the museum. Again, in the disclosure requirements, I don't see anything in there that says it's only a violation if you can show that she's also lying about it outside somewhere else, or that it's not a violation, or that the violation should be mitigated somehow, not as serious if in a private email with a resident, she has disclosed it. The requirement is that you publicly disclose it, that you file it. And the fact that she mentions her dual roles, her inherent conflict in texts and in emails, does not somehow substitute for her obligation to actually file it. And so, again, with regard to the violation they've admitted, they say, give her just a warning. I think if it were only that failure to disclose and none of these other circumstances, it still would warrant more than just a warning letter. But an argument could be made that a warning letter might be sufficient. But given all these other dual roles that she was playing, conversations, she claims that she never had any conversations with Sam Reed about the rezoning effort. Well, we know that's not true. She emailed him at least once about it when she forwarded that email from a constituent, mocking that constituent as just, a frequent flyer, a constant complainer. So we know that that's not true, that she did have some communications with him. And it's just not plausible that in being on the board together and all their other interactions, they never talked about it. It's just not plausible. But in any event, none of that really matters when you just focus on the actual elements of the provisions that are being violated. And we really hope that you will hone in on that in your deliberations, and that everything else, all the distractions, all the red herrings, don't take you away from that point. Thank you.
Council, can I ask a question? Council, I understand your arguments on subsections R, K, and O. Would you mind repeating just briefly your argument with regard to subsection Q?
Sure. So, and I think this is the one for which they've raised the counter-argument. Well, we never actually engaged her to do this. We didn't pay her as a representative. We didn't explicitly ask her to. None of that's required. The question is just, did she do it? So, when she, in her emails to constituents, to all of her efforts, not just the voting, was she advocating for the private interest of this nonprofit on whose board she sat? Absolutely. It doesn't say you have to be formally engaged as a lobbyist. In action, when in her council position, she advocates for the passage of this rezoning, does that advance the interest of the nonprofit on whose board she sits? And it absolutely does. Now, they're going to argue for a more strict reading that no, this is talking about literal representation, people who've been engaged, lobbyists, people who are being paid, that she can't literally lobby on behalf of. But that's, that's why you shouldn't sit in these dual roles, because it's not just a blurry line. There is no line between doing her job as a council person with regard to a desire of an entity on whose board she sits and doing what's in the interest of that entity. There is no line. You can't draw a line between those two things.
Let me ask you, at the risk of being a lawyer, let me ask you a hypothetical question.
Don't ever do that.
So I'm just trying to nail down where really you think the violation is of Q. And so if she had disclosed her board membership, if she had disclosed it under disclosures as was required, and if she is serving on the Metro Council, and she sincerely believes that the East Bank development is in the best interest of the city and her constituents, independent of the fact that her nonprofit may or may not have a museum in that space, is she still barred from advocating for the development as a member of the Metro Council?
And you're only asking with regard to Q, right?
I'm asking particularly with regard to Q.
Okay,
yes. Because
even under all those circumstances you just defined,
yes,
it's still a very clear violation of K and O.
Well, I'm not talking about
Yeah,
K.
you're asking about Q.
Yeah.
I would argue that if she had disclosed it, it still is not proper for her to both be involved in promoting a bill, and that's not just voting for it, advocating for it, promoting it, while also sitting on the board of an entity that will directly benefit from that bill. I just think you just can't get rid of that conflict. And honestly, even if you didn't know the law, common sense tells you you can't sit on the board of an entity while being part of the government, voting on something that will benefit that entity. That entity, by the way, only being involved to benefit someone who's asking for the legislation that you're voting on. And again, not just voting, talking about, deliberating on. Common sense tells you that that is a problem, but we don't have to go on common sense. We can actually look at the language. Does it create a reasonable impression of a conflict? Absolutely. And it's just compounded by the fact that she didn't disclose it.
Thank you.
You have any other questions?
Thank you. Mr. Cooper?
Well, so much for a short hearing. Sorry about that. Just to address this last point real quick about Q, I would note that there is a specific exception for council members who are expressing opinions and wishes of their constituents if they're not acting in some kind of direct representative capacity. That was not quoted, but it is subsection Q, subpart 3.6. Okay, so let's talk about, despite all the rhetoric, what we've actually learned today. We've learned that Councilmember Johnston served on the Children's Museum Board in 2025. We've learned that at her introduction, the museum had discussions with the East Bend Investor Group. We've learned that Councilmember Johnston forwards emails to lobbyists, including Sam Reed. I would suggest you look at the clerk's website and see just how many clients Sam Reed represents, because it's a bunch of them. That having a relationship with a lobbyist is simply not relevant to whether someone should have recused themselves from considering a zoning bill. Again, regarding the failure to disclose, we've stipulated it. We think at most the penalty for that should be a warning. This should be something that other council members look at and go back and review their disclosures to make sure that they didn't forget something. I mean, this is a teachable moment for the other 39 council members. So we think a warning for that is appropriate. But this whole notion of these relationships and all this convoluted problems with lobbyists, that just does not support a finding of a violation. I know that they didn't like the affidavits that were submitted, but they both clearly show that she was not acting as a representative of the museum throughout these discussions. Ms. Clinton's affidavit clearly states that she simply made this initial introduction and was not asked to advocate for the museum or for the zoning bill. Likewise, Mr. Biley's affidavit states that she was not asked to support the legislation. And again, the whole premise behind this ethics complaint is that consideration of that zoning legislation. That I think we have to keep that in mind. And there were zero commitments about whether the museum could even locate there. There's no agreement, there's no site, there's no commitments. This is all just conceptual at this point. So she did not use her position improperly to secure a benefit for the museum or for the developer. She did not give a reasonable basis by her actions that she could improperly influence any decisions. Again, we have to look at it, the code clearly refers to a reasonable basis. And under the lens of reasonableness, there's no indication that she improperly influenced anyone, or was she improperly influenced. There was no discussion about the museum in the consideration of this zoning bill. It was not part of it. Again, the vote was unanimous. She did not advocate for the legislation on the council floor and certainly didn't advocate for the museum. And like it or not, she did consult with the attorney to see how she should act once this ethics complaint was filed, and was told that if she didn't stand to benefit personally, then she did not need to recuse herself. And regarding subsection Q, which we've already talked about, I mean, there's no evidence that her role in voting in favor of the East Bend Development Ordinance was somehow in a dual capacity role. She was voting simply as a council member. I would also, getting to the lobbyist thing, council members of all elected officials, local legislative body members should be able to say whatever they want to whoever they want about legislation that's pending. I mean, providing opinions to constituents and letting lobbyists know about things and providing commentary, that's not an ethics violation. We might not like what some of those political statements are, but they're protected, and that's why we have the system that we have. So we submit that the complaint should be dismissed. Finding a violation here would really discourage council members from serving on nonprofit boards, and it would also discourage nonprofit board members from serving on or running for the council if they thought that, you know, that they were just opening themselves up for ethics violations when that is not what the purpose of the ethics ordinance was for. I've been doing this for a long time. I was advising the council when the initial ethics rules went into effect, which was before the state requirement. At the time, it was only applicable to council members. We had the Tennessee Waltz scandal at the state, which some of you may remember, where some state representatives were taking bribes and went to prison. And so as a result of that, the General Assembly thought it's a good idea for local governments to adopt ethics standards. So the council readopted those standards and made it applicable to all officials and board and commission members. But the purpose of those was to prevent wrongdoing. There's been no wrongdoing here. No one was on the take. No one benefited improperly. This is just a strained reading of ethics code provisions to try and find a violation because you don't like the outcome of legislation. And we submit that that is going to have a chilling effect on deliberations and council involvement going forward. So we would ask that you dismiss it or at most find a warning. Thank you.
Council, I have a question or two. You said in your closing, you mentioned that there were 0 commitments about a museum being in the East Bank development. I'm not sure that's relevant, but let's assume it is. I'm just confused by the statements your client made then in April of 2026, where, among other things, your client said that the East Bend development is planned complete with a children's museum, a planned children's museum on which I sit on the board. If there was no commitment, why is your client giving the impression that there's going to be a children's museum in the East Bend development?
She was referencing that those discussions were underway and were proceeding. I mean, both Mr. Byerly and Ms. Clinton have acknowledged that there was no agreement. They did not have an agreement and don't have an agreement today.
Okay, so why does the fact that there ultimately was no agreement make a difference if she is representing to her constituents that is part of the discussion?
She was attempting to, in context, she was attempting to tell constituents that this is not going to be another Broadway 2.0 because they're talking about family-friendly things like a children's museum. And so she was acting in her role as a council member to tell constituents this isn't as bad as what some people are going to be saying because they're considering family-friendly things like a children's museum.
So in order to dissuade a constituent about their concerns about the project, she used the potential existence of a children's museum for which she served on a board.
She did, and acknowledged in the email that she served on that board.
Thank you.
Thank you.
Thank you. Okay, so if there are no other questions from the board members to the lawyers or the complainant and respondent, at this point we can start our deliberations. And I know in the past when we deliberate, because it's public and the parties are still here, they may have additional information to clarify or to, add to the questions or concerns that we start voicing. I think we should establish some sort of decorum about how to handle that. If you like to hear from one of the other parties as we're discussing, it is, I think within your discretion to acknowledge them, but I would just warn both attorneys and the parties to not interject as we're deliberating. Please be acknowledged, and, we'll proceed that way, just to keep things orderly.
And just to clarify, if we decide at some point during deliberations that we have a question for legal counsel, we would go into executive session, correct?
No.
No? I thought that was in the procedures.
No.
Yeah, it's in the procedures for rare situations, but not this.
Not for
Not
hearing.
for this type of situation.
Okay, I must have misheard that. All right.
It's
Glad I asked.
a general statement, but
Okay.
there's no basis for an executive session.
Glad I asked. Thank you.
Yeah. But you are allowed to ask questions of Metro Legal Department, and her answers will be in public and on record. Okay. Yes.
I just wanted to mention something. The board's order reflects that the board voted to hold a hearing concerning 2.22, 2.020K, Q, and R, and to dismiss all the other claims. So I just want to make sure that we're within the parameters of the order and the decision of the board regarding the sections of the code for which a hearing was to be held.
Thank you for bringing that up. I had starred that because the complainants didn't argue about R, they argued about O, and O is not one of the provisions that we are supposed to be hearing evidence on, but I think it is within our discretion. Correct me if I'm wrong, Ms. Eke. If there's no objection from us considering the evidence in light of provision O, are we allowed to do that at this point?
The evidence, if it pertains to these specific K, Q, or R,
Right.
but not for you to make a finding regarding O,
No
because
finding.
that's not before you.
Okay.
What's before you is K, Q, and R, and evidence that's relevant to that.
Is that understood? Okay. All right. So at this point, we customarily will go around and each individual member of the board will voice any concerns or things that stick out to them or questions to, get some input on from the rest of the board members. I'm going to first say that I value service on nonprofit boards. I myself serve on nonprofit boards. I am not a member of Metro Council, so I've never been in a position of having to vote in that capacity on something that would benefit or impact any of the organizations that I care about. But it does concern me that we're in this situation of having a council member who's also a member of a nonprofit board kind of serving both functions, both roles, as it pertains to this matter of the East Bend development. It's concerning. It's also concerning that the council member cites her board membership and the potential placement of the nonprofit's museum in this development to address the concerns of her constituents. Mr. Sabas was getting at that with his last question to council. I also noted that. As a constituent, yes, you're telling me that you're a member of this nonprofit board, but you're also conveying or advocating the interests of that organization without addressing really the constituents' concerns about the overall development. So that raised a red flag for me. It also concerned me that the council member was sending disparaging emails about constituents and about other elected officials and about fellow council members to a lobbyist. I don't think that that's normal. I don't think that's appropriate. I'd love to hear from Councilmember Porterfield her thoughts about that type of relationship between a council member and a lobbyist, but that raises a concern for me. So that, of course, that's not everything that we can talk about, but that's just something to kind of get the conversation started. If anyone else wants to respond to that or make your own points, feel free. Yes.
I'll respond just specifically to the question that you asked me. I think different council members have different types of relationships with lobbyists, as well as like community groups, community organizations, labor unions. I think it is dependent upon the council member. I want to be very careful because I don't think that my standard should be the standard of the full Metro Council, so I just want to be really clear on that. I can only speak to what I do, if that makes sense. I don't have this level of relationship with lobbyists. We do get emails from them. I think that, to Councilmember Johnston's point, if there is a particular concern about a project, I think that may be appropriate to maybe ask a question about, like, I got this question, can you explain what's going on here, or something to get additional information. I don't send those types of emails to lobbyists that would be considered disparaging. I also don't have that level of relationship with the lobbyists. I don't engage with lobbyists much, but some council members do engage with lobbyists a lot. So I don't want to opine on what a council member should or should not do. There's a 40-member body and different people have different relationships.
Thank you.
Yeah, I just want to mention that we also need to keep the roles separate because the council member is a member of the board, but she's not a witness to these proceedings. She's just a member of the board. So she really can't testify, provide testimony. So I just want to, so we keep the roles clear.
I understand. I don't take what you said as any evidence for us to be considering. I just wanted to have a better understanding of a framework for the nature of the emails that we've seen. Anyone else?
Well, I mean, I will, not on that particular topic.
Any topic, we're open.
Just more generally, I guess I'll get things rolling here. I do want to say that I have served on nonprofit boards, and so I also respect the concern about chilling the interests of members of nonprofit boards from serving in public capacities. That being said, I think we have an acknowledged violation of subsection R here, so let's start with that. And to me, these different subsections are not necessarily mutually exclusive. They interact and interplay. And a violation of one combined with certain facts can result in the violation of another. To me, at least in my initial impression, that may be what's happened here with regard to subsection R and subsection K. You have a violation of subsection R. I don't know that, frankly, I don't know that it matters whether it was inadvertent or not, given the language of subsection R. I will note that it's a little concerning, the thought that someone's on a nonprofit board and doesn't realize they're on a nonprofit board. But I can understand there are oversights, people have a lot of stuff going on. But I don't think R really distinguishes, as far as the violation piece, whether it was inadvertent or intentional. But I think the lack of disclosure on R, which by the way is material because it is a public disclosure as opposed to a private email that came out in the closings, and I agree with that position. You know, it's certainly laudable that the council member is not denying her status as a member of a nonprofit board in private emails, but there's a reason for the public disclosure. And that public disclosure should have happened months before the private emails. And so the fact that there is a failure of disclosure in R, I think plays into whether or not there are facts sufficient to provide a reasonable basis to someone that there's an improper influence under subsection K, which it seems to me that when you take the lack of public disclosure combined with statements with regard to whether or not the development, there was actually a commitment to it, the fact that there are statements made in statements to a constituent that there is potentially going to be a home for this children's museum at the East Bank development, I think those two things combined, in my mind, are sufficient to also create a violation of subsection K. O, as legal counsel pointed out, is not before us. It's been raised. I certainly understand the argument on O. I will say that finding a violation of O in these circumstances does to me heighten the concern about chilling nonprofit participation in public affairs more than finding a violation of R or K. Same thing with Q. Is I'm a little uncertain as to where that line gets drawn, where you're actually representing or appearing on behalf of a private interest. I don't think it has to be that someone has to be expressly instructed to do so. That I don't buy into. But where that line is, I would love to hear other folks' thoughts on. To me, what I'd like to hear people's thoughts on are O and Q. More Q than O, given that O is not technically before us, but to the extent people have thoughts on O, I'd love to hear it. And then I'd love to hear people's thoughts on proper, we have a violation of R. I would maintain we at least related to R, have a violation of K. I'd be curious to hear people's thoughts on proper sanction. I am not of the belief that even if this was inadvertent, it can be simply ignored and the complaint dismissed. I don't agree with that. I think that leaves me right now considering possibilities of warning and censure. To me, I don't feel like it merits anything close to a recommendation that the person resign or anything of that nature. But I do think that there's a debate to be had in those lesser sanction realms. And so those are my thoughts just to kick things off is I'd love to hear people's thoughts on Q, potentially O. I'm open to thoughts otherwise on R and K, but I think there's violations there, and then that's where I am right now on the sanction piece.
Thank you, Mr. Sadis.
Can I get a clarifying question? Were you saying that you think that with regards to, I believe it was maybe O, that you think that this could have an impact on people serving on nonprofit boards?
I'm more worried about a potential chilling effect with O and Q than I am with R and K, because R, there's a reason for the disclosure, right? And people do need to disclose their participation on these things. And as I said, to me, the violation of K is at least in part tied to the failure to disclose under R. And so what I'm saying is, to the extent there is a concern that we don't want to chill participation on nonprofit boards when there's a non-pecuniary interest involved, like here. I mean, the rules don't limit it to pecuniary interest. But I do have more concern about a chilling effect with regard to O, a potential violation of Q and O, than I do the other two, is what I was saying. Does that make sense?
Any other thoughts from the board members?
So I guess in regards to Q, if we're saying kind of O and Q overlap of sorts, say for the fact that O is not before us right now, where does subsection 3.6 fit into this discussion as far as what the requirements are that state that nothing in the subsection shall preclude, and then it goes on to state, provided the member of council is not acting in representative capacity and does not receive anything of value for appearing before such board commission. I mean, I think at no point has been brought up that she received any sort of value in any sort of appearance whatsoever. And so with that subsection, does that not just put Q to bed, or am I missing something in that regard?
The piece that I would say I'm not entirely sure of, and it very well might, and I wanted to hear people's thoughts on this. She didn't receive anything of value for appearing. I do think it's at least a question whether she was acting in a representative capacity. She was a board member for the nonprofit. Whether she was expressly asked to do something or not, she's a board member of the nonprofit, and that should have been publicly disclosed at that point. And if it had been publicly disclosed, I would think there's at least an argument that she's acting as a representative when she's talking about her work with the nonprofit to constituents while she's talking about the East Bank Development Bill. So that's where I guess my question is.
Is Q also not just broken into two parts, that there is an or after a semicolon there. And it seems that 1, 2, and 3, including the preclusion, only applies to the second part if the represented person's interest is adverse to that of the metropolitan government.
Well, except for the fact that that's limited to judicial proceeding, and I'll focus again on subsection 6, which says appearing before any board, commission, agency, or department. And that seems to expand beyond judicial.
I think with subsection 6, though, it's saying to express the opinions and/or wishes of his or her constituents, and nothing that, I don't recall seeing anything that was directly related to the constituency. As a council member, constituents are like the people that live in our district. I would not think that a constituent would be the board you serve on. So I guess that's why I'm having a hard time with 6, because it doesn't seem like, I didn't see anything that was directly related to, I didn't see any evidence that was presented that said residents of this particular district were advocating for this to the council member, and the council member was advocating on behalf of her constituents.
I agree. There's been no testimony or evidence given to say that the council member was expressing the opinions or wishes of her constituents. So even if 3.6 is applicable, it's not. It doesn't come up on these facts. So the question is her membership on the board, her communications to her constituents about her membership on the board in relation to the East Bend development, and her duties or how she functioned as a council member of Metro Council, does that give rise to a violation of Q? I was reading Q when it says shall not personally represent or appear in behalf of the private interest of another before the Metro Council. I was taking that literally, as in you're in the council, you're speaking, you're on the floor, you're advocating to your other council members. And I didn't hear any evidence of that happening. So I didn't think that there was a violation of Q, but we should continue talking about that.
I agree with that. And I see no evidence of a violation of Q on the facts that we've heard.
And there was a comment that was made, I can't remember who made it, but someone made a comment about if Councilmember Johnston influenced council members, and I don't think that she did. And again, I can only speak for myself. I don't recall, I think it was stated that she did not speak on the particular legislation. Tennessee has very strict open meetings act, so council members aren't supposed to talk to each other outside of meetings. I don't recall Councilmember Johnson speaking on the floor about this, so I would not think that she influenced council members to vote in a particular way based on her position on the board. So I wanted to name that, and then I also wanted to speak to another comment that was made about if this will have an impact on council members serving on boards and commissions, nonprofits. I don't see this as having an adverse impact on council members serving on nonprofits or on people serving on boards to then not run for council. I do agree with what Mr. Cooper said, Attorney Cooper said, as regardless of what is decided, because I'm not opining on what should happen. I'm just kind of speaking as from a council member. Regardless of what is decided, I do think that this will make council members be more careful in being extra thoughtful about their disclosures. I don't think that this will then stop people from serving on boards. I keep saying boards and commissions, but I mean nonprofit boards.
Yeah. And I'll just say that the evidence we heard from Councilmember Johnston's testimony was that she didn't speak to any other board members about the East End development or the potential placement of the museum in that area, and we didn't hear any contrary evidence from the complainant. So just so we're clear on that.
So perhaps we can do a motion on Q, or do you want to do it all together?
I think we can do it all together when we get to.
One other comment on Q, just to address it, because you raised the semicolon with the or there, and I read that way at first too, and I don't think it's a particularly well-structured section, but to me, the thing that makes paragraph 3 apply to all of that first paragraph is the language of subsection 3 says, provided that nothing in this subsection shall preclude, and I think the only way that makes sense is if that includes Q as the subsection. I think what's happening there is that number 3 really shouldn't be a number 3. It should be a continuation of the beginning of Q. But I see where you were going, but I think ultimately, I think that the provisions of 3 apply to Q as the whole subsection.
Okay. Any other questions or discussions about Q before we turn to R and K? Or, Mr. Sabas, do you still want to hear thoughts about O?
I'm happy to hear. To me, R and K, regardless of O, to me, R and K are where the crux of this is. I'm happy to hear about.
I agree. And I think it must be stated again that the respondent has conceded a violation by not including the board membership on the Children's Museum in her disclosure in a timely manner. And to Mr. Sabas's point, the lack of that public disclosure has some bearing on K, which is shall not give reasonable basis by their conduct or the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they are unduly affected by the kinship, rank, position, or influence of any person. I see in this situation 2 potential improper influences. One is the Children's Museum itself as an entity, and the other is the lobbyist that she's communicating with. It appears to me as if I'm a constituent and my council member is telling me I'm a member of this children's museum and we might have a home at this development, so you shouldn't worry about the nature of the development or what's going to be there. I can allay your fears there. That to me plays towards a potential improper influence, or that the museum unduly enjoys her favor in the conduct of her business as an elected official. And then the emails with Mr. Reed, I've already mentioned, if I were Mr. Reed and I have a council member forwarding me information, making characterizations about the people who are raising concerns about the various issues that affect that lobbyist client, and just the nature of the way she's describing these other people's concerns, if I'm Mr. Reed, I get the impression that, she seeks my counsel, she cares what I think, I can probably influence her to do what I want. That's what I would see those emails as. Anyone else have thoughts about R or K?
I think R is straightforward, and just to be consistent with our board and our agreement, when there's a failure to disclose, there's a violation. It's kind of written into the clear, plain language of the code. So I don't think we think to be consistent, we have a violation there. I don't know that it's so, I don't know, several members have talked about the relation that R's violation informs K. I'm not sure. I see them more standing separately. I don't think there was, and I don't think the failure on R was intentional to not let anyone know that there was an involvement. I didn't hear an intentional failure, an intentionality in responding. Now, it is curious, given the stream of communications, how it wasn't remembered, but we've had lots of things not remembered by council members and their disclosures. This is not the first disclosure case we've had, so I don't think we have to think a lot more about, in my view, R. And I think K raises concerns. I think the 2-hat problem is a concern for all the reasons so ably articulated by other members here. It is a concern. So I think the question is, what do we do about that? to what extent does it add on to whatever we find on R? Is it a standalone violation? Perhaps. And then of what magnitude and what do we do with it? I do think that standard K is hard. It's hard for council members. Reasonable impression that someone could be. I think someone has been. I don't think it was unreasonable to question whether there was two hats happening here, and whether that two hats meant that the constituent hat was being affected by the hat kind of excited about the museum moving forward. So I think it's a high standard in this code for council members in terms of everything they're doing, their activity, to be constantly monitoring. Could I be giving the impression, is it a reasonable impression that there is something out there, person, place, or thing, that could be influencing how I'm serving as a council member? I think the emails, again, I think ably described by other members here, I won't repeat it, but I think the emails, particularly to the constituents saying, I know this because of this hat, reasonably would make a constituent wonder, well, but I want my council member to just be being a council member, unaffected, uninfluenced by any other activity that he or she may have. So it's a hard one, because I read all of this as kind of enthusiasm for the development in a children's museum. I think I agree, there's no wrongdoing here. I don't see any wrongdoing here. I do think we have a very high standard, and there was some falling short of the very high standard that council members have to deal with as council members under this particular code and this language. So I do think there is a concern on K. So I think R is a clear violation. I would find a violation of K. I think, again, falling short of a very high standard, taking into account that there's no, in terms of sanction, taking into account that there was no wrongdoing here, that there was enthusiasm and maybe not reflecting on how it could seem. And that at some point, maybe when the two things came together, to realize, hey, this might be uncomfortable, two hats. Maybe it's time to step down from the museum board if this could conceivably happen. Maybe that would have been a time to step down from the museum board. I don't know, but I think we can. I feel we can move to that discussion. I'm hearing somewhat consensus.
Yeah, I think intentionality, of course, is not a requirement for finding a violation of any of these, but I do agree that it goes towards our deliberation about the appropriate remedy or action that we would take in response to finding a violation. I will say that in my mind, serving on the board, if she had disclosed her board membership and she still, voted on the development, knowing that it could benefit the children's home, I don't know that we need to find that she should have recused herself. Like, I heard some argument about that. I don't know that we need to find that in order to decide if there was a violation. So I just wanted to say that out loud. I also just wanted to say that seeking the advice of counsel after the fact about whether she should have recused herself because of a conflict of interest is not relevant either to whether there was a violation of Q or R.
I think we have let's just get the time right.
She sought counsel before the
vote, not after.
No,
Before
after.
Before the final and third vote, but she had voted previously on it.
Okay,
Correct.
Okay.
Right, and for me, the violation, I'll clarify, the correspondence with constituents that was happening before the final vote,
Yes.
to me, it goes to K as to whether there was a violation of K.
I agree.
And that was before this advice of counsel, because that was after the ethics complaint was filed.
Yes.
Is when she sought counsel. I don't think we have a question.
Can I make a correction to the
Okay.
facts?
Yes.
Okay, thank you. Third vote for the ordinance for this very significant rezone was actually going to be on April 7th, I believe, that Tuesday, when I wrote the council member. So there was a deferral for one meeting. So that was going to be the third vote that night before the council member received or asked any questions about recusal.
Thank you.
So then,
Okay, thanks.
okay.
I also think it's not relevant that the vote ended up being 37-0 or whatever it was. The outcome of the vote doesn't go to whether there was a violation of K or R. The fact that there was not a written agreement for the museum to be in the East Bend also is not relevant. So I guess in terms of moving forward to a vote, does anyone else have any questions, thoughts, concerns before we vote on whether there was a violation of K or R?
We're talking about just voting on the violation at this point?
Yes. No questions about that. And then we'll talk about what the appropriate action should be. Okay, so I'll entertain a motion as to the provisions before us. And again, that would be K, Q, and R are the provisions before us to find whether there's a violation.
I would move to, that we find violations of subsection R and K, but not subsection Q.
Is there a second?
Second.
Any discussion? Okay, and then do we need to do a voice vote? Okay.
Roll call, please. So there's
Chair Young?
clarity.
Yes.
Ms. Tiani?
Yes.
Mr. King?
Yes.
Mr. Savis?
Yes.
Mr. Wicker?
Yes.
It's 5 in favor, 0 against.
Okay.
Chair, for the viewing audience, as a reminder, I'm not a voting member, just for anyone that is watching in the room or watching in the sky, just for the record, I'm not a voting member.
Thank you, Councilman Porterfield. Okay, so this board finds that there was a violation of standard K and standard R in the rules of ethical conduct and not a violation of provision Q. So now the question is, what is the action that we should take as a board? And I'll just note that the rules lay out our options. And I just had the section in front of me, and now I can't find it. Okay, so we can either issue a written warning to the elected official with a copy to the vice mayor or executive director and chair of the applicable board or commission. Such warning should include the violation that occurred and any remedy the board requests be taken by the elected official or member of the board or commission. That's 1. 2, we could issue a public censure of the elected official or member of the board or commission. 3 is recommend to the council that the elected official or member of the board or commission be censured. 4 is recommend to the violating elected official or member to resign his or her respective position. 5 is refer the matter to the district attorney for appropriate action. And 6 is refer the matter to the director of law with the request that appropriate civil action be instituted by Metro government for restitution or relief. I believe that we've already sort of narrowed this down to 2 or 3 options: a written warning, a public censure, or a recommendation to the council that the member be censured. I'm not hearing anyone advocating for recommending that the board member or that the council member resign, or that we refer the matter to the DA or the Metro Director of Law. Is that fair?
Yeah, can I ask a question? And this is the question that if I were going to think there might be an executive session, I would ask, because I'm relatively new to this board in the grand scheme, and, you know, I'm happy to look like an idiot publicly, I guess, but and maybe this is a historical question of how the board has perceived it. I'm curious as to the circumstances that would warrant the difference between subsection 2 and 3, us issuing a public censure as opposed to recommending the council do so. And so I don't know if y'all who have more experience on the board than I do can answer that. What would be the difference in circumstances between those two?
So we can have legal, but these are new provisions, and I think a public censure, well, it is public. You're right. It would become we are the entity censuring, not council.
So it's really just the difference would be council being censuring
Our
and the
community
versus
board
us.
would be censuring,
Okay.
not Metro Council.
I didn't know if there was something else. Okay.
And I will say it, I mean, I'm just gonna jump in if we're ready
go
to
ahead.
talk. I'm saying, I don't think we've seen facts that would even would support in any way the third issue of a public censure, a council censure. I don't think I'm not seeing any activity, any behavior could rise to the level of a council public censure. That's what I'm seeing. I'm gonna throw that out.
I would tend to agree with that. I asked the question because I mean, look, I understand the concept of the council doing a public censure being a more severe punishment than us issuing one. I didn't know whether there's any more detail
Right. No, I understand.
that led to that distinction here other than that. To me, the challenge here is between warning and public censure. I'm happy to hear arguments to the contrary, because I do think that I don't think this is much ado about nothing. I think these are meaningful violations. I do think that, to me, and I understand that there's some difference on this, and it's just maybe just perception the way we look at it. The failure on R contributes to the failure of K, and to me that mitigates the fact that you have 2 violations. To me, doesn't necessarily merit a more significant sanction than having one when the 2 interplay that way. That's just the way I think about it in my head. But I do want to hear people's opinions on warning versus censure, because to me this falls in that realm, and I'm having trouble pulling out which one I think is more appropriate.
I will say that we don't have to just do one. The rule provides that we can take one or more of the following actions, so just so people know that you can have one or both of those 2. Yes.
I agree with the assessment that I don't believe it rises to the Metro Council doing a censure. I don't think that that would be appropriate in this case.
Okay. Anybody want to argue in favor of Metro Council? Okay. So we can take that off the table and focus on written warning or public censure from this board.
And I will say, I think that this board has never done a censure, because it's a new sanction that we've just recently received. It was an amendment that the council gave us additional powers very recently. We've never done one. And just to spell it out, it'd probably look like it would be in order and said, this is a public censure, and this is why we're censuring it. It would look a lot like a written warning.
Right.
So it's really how it's captioned. I mean, you could, on a written warning, have a bit of a talking written warning. Written warning, this is what we found, falling short of standards in this way, which would largely also look like a censure. I mean, I'm not sure, other than the word on the order that gets signed. So I just think we can let's think about literally what we're talking about, some language about, because either way, we're finding that behavior, the evidence came in saying that behavior fell short of the standard in K.
Oh, yeah.
Could we hear from legal on the difference between the written warning and the censure?
I think a censure is more severe than a warning, the way it's.
Progressive,
Yes.
right, progressive.
It's a more formal statement of that's a little bit, carries more weight than the warning in terms of severity. But the board, yeah.
But both of them would be made known to the public.
Well, a written warning is issued to the official and a copy is sent to the vice mayor. It is a public document anyway, but it's not, a public censure is publicly disclosed without the need for any records request, that it's a public statement.
So, just so I, for purposes of the board operations and just understanding going forward, our meetings are public, but someone would have to, like, say, go to our website or go to the YouTube channel to see what we've done or actions we've taken, right? Like, we don't make an announcement or do something just from our normal operations. But if we did a public censure, what would the dissemination method be for that? Like, how would it be public?
Well, it'll be published on the website.
But our minutes are also published on the website.
Yes, I mean,
It would be in the case file on the website, like everything else we've done, all other orders.
But so in that situation, someone would still have to go to our website and see it. Like, it's not going to be like we're not going to put it somewhere other than on our website, correct?
It would be, I mean, if it's in the case file, if you go into our cases that the clerk's office keeps, you'll have all the cases, and it will say what the result is. Right there, it'll say whether there was a sanction or not and what the sanction is. So anyone interested, any member of the meeting, would be able to go in and see right off the bat without even opening the file, that there was a public censure here.
Okay. Again, that place is on our website.
It's on.
Okay. Yes.
And we have a member of the media here taking diligent notes. I see his little fingers going. So I'm sure whatever happens is going to be a write-up about it in the media, in the paper. But if I understand correctly, I think the biggest difference is a written warning to the council member will go to the council member and will be shared with vice mayor. A public censure will be to the public. I see that as like the biggest difference. Like, do you all believe, and again I'm saying you all because I'm not opining on this, but do you all believe that it rises to the nature that it is a warning to Councilmember Johnston and council members and vice mayor are aware of that warning, or do you all believe that it is it rises to the occasion that it needs to be publicly disclosed to the public? That is my understanding of the difference between the written and the censure based on what you just said.
Well, one is really more formal, which is the censure. It's a more formal statement regarding and kind of a record of wrongdoing. So it's a more formal act by the board to issue a public censure as opposed to a warning that's just directed to the individual.
Okay.
So again, it's a in terms of hierarchy, the second one, it's really a more formal form of quote discipline. It's that carries in the hierarchy of severity.
Okay. So we're all clear that a public censure would be a more severe penalty than issuing a written warning. Does anyone want to make a motion or share thoughts about which one we should recommend or which action we should take?
And just to be clear, because in common parlance, sometimes we think of written warnings as, hey, if you did this again, you're going to be in trouble. These written warnings are a finding of a violation, okay? It is a sanction. So although when they were giving us these additional powers, they called it a written warning, but it is, we have met, we've heard the case, we found a violation of the standards, there is a violation, and now this is how you're going to be sanctioned. And we even can disclose, we can direct the respondent to take some action. That's the power of a written warning. So it is a finding. I just didn't want it to seem like, because often in employment law and so forth, if it's progressive, so, and I guess what I was saying is, I'd be interested in hearing everyone's thoughts about the two options. I guess I was just saying that you could, in the written warning, you could have a statement of the falling shortness, if that, the finding. And I think from a practical perspective, yes, formally it's progressive and it's more serious. Maybe the media would talk about it differently. Maybe the font would be bigger. Practically, it wouldn't go to the censure would not go to the vice mayor. The written warning would go to the vice mayor. They both go on our website, and it's really, how would they be characterized by the media, I suppose, is the question.
I don't care how it would be characterized by the media.
Okay,
I don't know.
but I'm
I don't
saying
have a better way to say
practically,
that.
but I'm saying just to let folks know what we're talking about now, because we have to come to a decision on two pieces of paper. That's what I just, because this is a new thing for this, so.
Yeah.
What is it, what do we want to call the paper?
Did you have something?
Yeah, so, I mean, it seems like we found a violation of R and K, so at the minimum, there is something, right? It seems like the minimum might be the warning, and really the question is everything else that we've heard here today enough to bump it up to censure? I think that, to me, it's really just what do we think happened with the sequence of events. I feel that I'm a little uneasy about the timing, because it seems that all of this stemmed from a meeting in November where maybe but for membership in this board, the introduction would not have been made, right? This introduction all came from the council member's position as a council member. That's why she was invited to this event. And about a month after this initial correspondence, that is when this disclosure form was required. So it does seem a bit strange to me that so shortly after the answer no was given for that question.
Yeah, that's a fair point Mr. King is making. I'll just also repeat it. So the invitation to the East Bend developers meeting to certain members of the council was in November of 2025. At that meeting, Councilmember Johnston spoke with David Brierly and offered to connect him to the CEO or leader of the Children's Museum. And then in December of 2025 is when the disclosure statement was filed, which listed no for the question of membership on any nonprofit entity. Does that hit anyone differently or influence where you would land on the written warning versus public censure?
I think it's surprising that the answer was no, but I think the membership was earlier in 25. I think the council member was a member of the museum board, and there was some activity prior to that November date. So there was, I think, a longer period of being on the board. So it's not clear what happened, why the answer was no. It's curious, and I think you said it well. People are busy. People, maybe. It's an unknown, it's unclear. So it is concerned, so we find a violation. We don't have to really get behind it, because we won't know. Was really busy, distracted, thinking financial, there was nothing, and just forgot about it. We don't know, and we don't have to know on that. So there's a violation because it's a factual thing, no. Then the question that I think we have to look at, as you put it, so well, Mr. King, the bump up. What is the bump up to censure? Let's articulate what is the behavior that would bump it up. I was hearing, and I agree, I think there was a two-hat problem. And, you know, was it, should have been even foreseeable at some point, maybe by this November date. Maybe that's when it should have been for November 25, foreseeable that it's time to avoid the two-hat problem, to avoid this provision K. She needed to get off, you know, it was gonna be because likely if this thing is going forward, this is, now the council is engaged, right? It was a presentation to council. They were going to be looking for rezoning or land use zoning, and at that point, the council should have just been the priority and said, well, I can't be involved in the museum if there's any connection between these two things. I've got to get off the museum board. That would be ideal. That's a high standard. Someone really, you know, sat down, read it.
I'm sorry, I disagree with that to the extent of like, you wouldn't have to step off of that board, but you could just not engage in that manner of like, you can still be on the board and you still can be like supportive of those projects, but then you could say, I am not going to be like the one that's kind of in a negotiation or in these conversations. Like you can still stay on the board and say, I'm not going to engage in this capacity. I just want to be clear, I don't think that requires council members to step down from board memberships.
Okay, then play that out then. Then what exactly was the behavior that would bump it up from a written reprimand?
I do not want to opine on whether or not y'all should do a censure versus I don't know what that difference would be, and like,
Okay.
Respectfully, this is my colleague, you know, so I don't want to.
We're just looking at, we're trying to discuss the evidence.
Well, for me, so you have, the facts are, she's a board member, she's a council member. Those two things are facts. If that was the end of it, then I would say we're squarely within the written warning zone there. The increasing, or the thing that would bump it up, is her communications with her constituents about this project in relation to her role as a board member. Like, she's telling constituents, oh, don't worry about the East Bend. Children's Museum is going there. I'm a board member. Like, that's the extra to me. And then you have the emails to Sam Reed.
Well, so let's just do the first thing, the constituent, because I'm uncomfortable with it, but when you think about it, could she have responded, I mean, so you're saying it's okay that she had both hats, but
it's not okay, it's a violation.
Oh, so
it was a violation for her because she didn't disclose.
Right, forget about, we have that. We have R. We're only talking about K.
Right.
R is a written warning, I think. Just K, step it up to a censure, a board censure. Isn't that what we're talking about?
I'm not reviewing it that way. I'm saying we have violations of both.
Okay, and we're looking at
the circumstances of those violations, the facts that have been brought before us to decide, should those two violations, K and R, be a written warning or a public
Right, so what I mean is, we know there was a lack of disclosure on the form. We've got that. That was the one behavior that was a violation. Now we're looking at what were the other behaviors that were a violation, an additional violation that would bump it up to a public censure by us. And we just said, our council member said, her view is that you wouldn't have to get off the board in November of 25. And I thought you just said she could have stayed on both boards, council and the museum board, and that those two hats, that wasn't a behavior, just being on the board. Not, because I suggested, well, she could have withdrawn at that point to avoid any conflict of interest, any two-hat problem. And you're saying, but it wasn't the two hats, it's just staying at that point on the board. Was that the behavior that was the violation of K that bumps it up? Or you said it's her use of her position on the museum board with her constituents that creates reasonable basis for concern that there's an external influence on her, separate and apart from her council hat, that there's this museum involvement, and that was the violation of K, and we're looking at what the specific, as we're trying to assess how progressive the sanction is, we're thinking about what exactly is the behavior that we want to sanction. So is it just that she stayed on the board once she knew, as of November 25, she saw these two roles coming together? When she introduced the developers to the museum, she saw the two roles coming together. So are we saying the thing she's got to be sanctioned for the behavior of not getting off the board at that point? Or is it okay that she stayed on the board at that point, but then the sanctionable behavior is that she told her constituent who was concerned about the development that she was on the board, she wore her museum hat, responding to a constituent, and that's where the two hats became a problem for the constituent that's so obvious that it would suggest an influence that that behavior is the additional behavior that's sanctionable, which makes us, helps us figure out what level of progressiveness of discipline or sanction. Do you have any thoughts about that?
I'm separating them into two buckets. I think R is straightforward. The evidence was it was inadvertent. She corrected it. I don't know why we do anything more than a warning there. In regards to, is it K? I don't have an issue with the fact that she stayed on the board. I don't see that being problematic. Again, council members can serve on boards. It's, the situation that merits how you wear those hats. If we're focusing on this one exchange with the constituent, then, I see that as bad optically, such that it triggered the, reason we're here today. But I'm not seeing more that merits a censure. I think these can be isolated. I think we look at a warning for both.
Yeah, and I guess that's the problem I'm having. If we look at the email, yes, that's why we're here today. But what if it's okay for her to be on the board and the council? Could she have said to the constituent if she had not disclosed her board? Her disclosure of her board membership was disclosing.
Yeah.
To the constituent. It was transparency. It wasn't, if she had been on the museum board and not said it, and not told the constituent about it, wouldn't that have also been a problem? Because now she's even in a conversation about this. So I'm just trying to really zone in on, because I'm kind of agreeing, I'm not, until I hear an articulation of, I don't know if I can get to a public censure. I don't know.
And just to be clear, I'm not saying that specifically
Right.
means that you do a public censure.
Right.
I was
No,
saying
I know.
that's the conduct above the finding of violation
Yes.
that I'm considering for
Yes.
what the
Yes.
appropriate action should be.
I want to respond because I don't want my words to be unintentionally miscategorized. So I want to start by again saying I am not opining on written warning versus censure. What I am opining on is with regards to service on council and also being on a board, you can hold both without there being crossover. So if there have been instances where I have had more of a relationship than just a typical council member relationship and something that's going on, and if someone comes to me on it, I will literally tell them to go to another council member because of my relationship with this thing. So I think that there is a way to say, yes, I'm on a board member, I have a relationship, or whatever the case may be. I don't want to confuse my two hats. So there is a way to say that you can go to another entity or another person. And I don't think that Councilmember Johnson did anything malicious with regards to and I know y'all talking about the intent doesn't matter. I don't think she intentionally tried to hide that she was like a member or whatever the case may be. But I do think that there is a way to serve on a board and still not allow those worlds to cross over.
I agree. And I also agree with your earlier statement that she wouldn't have been required to withdraw from being on the nonprofit board. I think in this situation, how she should have responded to the text message, I don't know that I have an answer for that or that we even need to figure that out. I just think the fact that this is a controversial land development. People have concerns, they have problems with it. And as a council member, you're talking to your constituents from the perspective, not just as a council member, but you're interacting with them as a board member of a nonprofit. Like your communications with them are in that role in addition to the councilmember role. That's what I'm focused on.
So I find myself as I listen to this, and thank you, this is all very helpful. I find myself as I listen to this leaning toward the warning. And I'm trying to articulate to myself why. And maybe to the extent I'm doing that in my head, it might be helpful. I agree that, you know, the failure of disclosure gets you at least to a warning. I think the question becomes what exacerbating circumstances do you have that raise it from the warning level to the censure level? For me, what would counsel in favor of that, to the extent there's anything, is the established nature of the relationship for multiple months before the failure of disclosure. I find that concerning. Was it intentional? It would seem to, the fact that she was willing to openly discuss it with a constituent later seems to indicate it was not. And so very well may have been mistaken, but there's different levels of mistake too. And so I find that piece troubling. That to me would be what would elevate it. I guess the big piece that has me leaning toward the warning right now, and counsel pointed this out and he was correct, there's no pecuniary gain here of any kind. To me, if there was a person that we know of, if there was a personal pecuniary gain, to me, in my mind, that raises it to the level of a censure. What I don't want to do is say you have to have a pecuniary gain personally in order for there to be a censure. I don't think that's right. I think but I think that you have to look at the circumstances of each case. I'm just saying that the absence of a pecuniary gain to me is what I think has me leaning toward the warning side of this. I find the failure of the public disclosure troubling, but given that I can see how that can happen accidentally, even if it's a significant mistake, I find myself leaning toward the warning because there was no accompanying financial benefit.
Okay. Does anyone want to share any thoughts on the contrary, advocating for a public censure? If nobody's pushing for that, then we can just go ahead and proceed with a written warning and discuss any remedy that we request that the council member take. Okay. Hearing no one advocating for a public censure, we will focus in on issuing a written warning. Is there any additional, so the warning should include the violation that occurred and any remedy the board requests be taken by the elected official or member of the board or commission. In this situation, the elected official has already resigned from the board, so I'm not sure. That would have seemed to be an obvious thing, but you know, as we've discussed, there are different opinions about whether that was even necessary, but in light of the subsequent conduct, is there anything additional that we would recommend the elected official do at this point?
Because she's also updated her disclosure, so those two
She did,
things have
yes.
been corrected.
She updated her disclosure and then she subsequently withdrew from the board. Is there any additional steps we think are necessary in this situation?
I mean, given that the service that caused the nonprofit board service that led to the problem no longer exists, and given that the votes have already taken place, to my understanding anyway, on the project, I don't know that there's something specific that I can think of. To me, it'd be more of a statement of, you know, going forward, please bear this incident in mind, this violation in mind, and be especially careful with regard to future disclosures of this nature, because there will now be a record of a prior problem. And of course, to the extent that any future votes come up that are relevant to this project, there should be particular scrutiny as to whether recusal is appropriate.
Okay. Does anyone have thoughts about that? Any additional language we should consider for the written warning? Okay, well, is there a motion?
Somebody please don't make me say that.
I don't know if I can regurgitate that. So are we moving to issue the warning for both violations at this time? I'll make that motion.
I'll second it.
Okay, and we'll do a roll call vote.
Chair Young?
Yes.
Can I say, I just want to have a clear record. So the only motion made was to issue a warning. No additional verbiage was added to that motion. Is that correct?
I mean, do we have to?
Well, I guess.
No, you don't. I just, for my own clarity of what I put down.
Yes, right.
I need to make sure.
I think it was based on what Mr. Sabis said.
Yeah, if there's additional verbiage, it needs to be articulated. If it's just a letter, because this letter is going to be drafted, the board chair, essentially you delegate on the board chair to issue this warning. So we just want to have clarity of the record that.
So I'll write out what I think Mr. Sabis was saying, and then I'll.
This is being recorded, correct?
It's being recorded, but I do need the motion maker to articulate what goes with the motion.
Okay, but maybe to make this simple, could he say, well, if this is what he thinks, could he change his motion to be, a warning in line with what was previously said on the record by Mr. Sabis, or does he have to actually restate the whole thing?
Yeah, I would like
Or should I
for
make
it to be restated, so there's clarity.
I need to make the motion.
Silly. All right, so you want me to make the motion?
I mean, it makes sense to capture that verbiage correctly.
You could propose the language, and then he could still make the motion.
Okay, so okay. So I think what I said was, given that the nonprofit board position that created the problem is no longer held, and that to my understanding, the votes have already been taken, the warning would not contain a specific request or recommendation for action at this time. However, would note for the council member that this is a finding of a violation, to be aware of that finding of that violation, and to be sure to take that into account for any future disclosures, given that there is now a record that there was an issue with this one, and of course, to the extent that any future votes arise with regard to this particular project, to pay particular attention to whether recusal is warranted at that time under those circumstances.
So with that being said, I move again that we issue a written warning for the two violations and incorporate the language that Mr. Sabis just articulated.
Is there a second?
Second.
Thank you.
Can we proceed with the vote? Okay.
Chair Young?
Yes.
Ms. Deani?
Yes.
Mr. King?
Yes.
Mr. Sabis?
Yes.
Mr. Wicker?
Yes.
It's 5 in favor, 0 against.
Okay, so we will provide the written warning to the complainant or the outcome of this hearing to the complainant and respondent, along with a written warning to the effect that has been articulated. We do not have any other items on the agenda, I believe. We don't have any other matters pending that we need to schedule. So we can adjourn if there is no objection. Do you have a question?
I just wanted to say thank you very much for your time. I think ethics laws matter and your time matters, as does everyone who's worked on this. And I just want to say I really appreciate it. Thank you.
Thank you. Okay, no objections to adjourning. So we stand adjourned.
Is the, how does that go?